ಅಲ್ಲ ಅದೆಲ್ಲ ಮಾಡಬಾರ್ದು ಅಂತ ಮಾಡಿದ್ರೆ
ಅಲ್ಲ ಊರ್ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಹಾಕೋ, ಬೇರೆಯವ್ರು ಇದ್ ಮಾಡಂಗಿಲ್ಲ.
ಇದು ಕೊಡು, ಇದು ಮೇಲೆ ಇಡು.
दरवाजा बंद करते अपना।
हाँ जल्दी है।
लग गया
सर ऑडियो म्यूट ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್ ಕೋರ್ಟಲ್ 2 ಇಂದ ಲೈವ್ ಇದೆ, ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಇದೆ.
Court of sitting later.
by Justice Keshav committee. It's a new writ petition, my lord. Tomorrow, my lord. My lord, on last date, my lord, in another writ petition, my lord, the VDA has taken undertaking that they will not sell the property in respect of that particular petitioner. The lands, my lord, the allowed shares, my lord. The same order may kindly be. Because, my lord, there is urgency, my lord, because of that undertaking, my lord. They may. We'll have it tomorrow, please.
Matter arising from Lord, this is a matter arising from a land grabbing court case. In fact, the petitioner herein had filed an original suit seeking for declaration of his rights. The matter gets transferred from the district court to the land grabbing case. And here it is converted into a prosecution against him. And the matter requires some intervention. Date is on the 4th of October, man. 4th of October. Land grabbing court. Trial has been ordered.
For the matter transferred from there.
It is in August.
Don't worry, not on the last day.
We had to accumulate all the records from the Mangalore court and also come before this honorable court.
Are there any civil suit pending?
Civil suit is transferred. Civil suit is transferred to this honorable court.
It's on 4th October.
4th, please. Great.
For adjournments, my lord. Please.
For petitioner side, my lords.
Practice not to do some highly be absent. Member of the district court.
Madam. Submit.
One of the petitioner side, my lords, the petitioner council practice has been barred, my lords.
District
My lords, writ petition, my lords. My lord,
Last week.
district forum, my lords.
sufficient.
GMRES, my lords.
Practice has been barred.
The petitioner is the bar.
Whose practice?
My lord, the council for petitioner, my lords. Yes, ma'am, because he is the authority in the district forum, my lords.
He is the member.
Yes, my lords.
Well, party.
My lord, kindly post it for tomorrow, my lords.
Yes, wait. Call the list.
For adjournments, page number 10, 19 to 20.
Hello.
Page number 11, 21 to 24.
My lord, serial number 21, my lord. Lord, senior is not keeping well, my lord. Matter may be taken up after vacation, my lord.
Which one? Which one?
Serial number 21, my lord. I've informed the other side as well, my lord.
Appear for respondent form.
At the request of counsel for the
Appellant, my lord.
appellant on the ground that the senior counsel is in some personal difficulty.
Personal difficulty, my lord.
Adjourn to, just give it.
My lords, serial number
27, 11.
24. My lords, serial number 24, my lords. I'm appearing for the respondent number 1, my lords. My lords, there's a little inconvenience for the respondent number 1 counsel, my lords, as there's a demises in his family. I've already informed the.
I appear for the appellant in this case.
You
All the
appear
matters.
for all the
I'm
respondents
the respondent number 1, my lords, in all the cases.
in all the cases at the request of counsel for the respondent number 1 in all the appeals for an adjournment which is not opposed, adjourn to. So this will 24 to
Fine.
24.4.
Please, my lords.
Please. It will be taken up. My request is to.
Ma'am. In which one? 3 also and 4 also. 24.4.
Totally 5 matters, my lord.
The counsel for the appellant shall just say this, that notice on the unserved respondents,
Lord,
In
already
this-
served. Is served.
24.3,
Please, in
24.4.
all the matters we have served.
The learner counsel for the appellants states that all the respondents in this batch of appeals have been served.
Please.
The submission is taken on record. Next,
27/11.
Maybe,
My lord.
date may be fixed.
27/11.
which month?
27. Date 27/11.
Date may be, I request.
Let it be here.
Please.
Next,
My lord.
Page number 12, 25 to 27. Page number 30, 28 to 35.
Lord, serial number 30. The counsel appearing has some professional inconvenience.
in item 30,
30.
I'm for the,
this is
Respondent.
consumer, na?
Lord, I'm for the respondent. I seriously oppose his adjournment. The reason is this, my lord. Lord, they have suffered the order till National Commission of India. That is consumer matter, my lord.
Just wait, we'll
Lord,
just,
the counsel himself has some professional inconvenience. That's what. SN Prashant Chandra. I'm seeking
NBW
adjournment in serial number 41 also.
Lord, when NBW has been issued by the executing court, then only they have approached this honor court without approaching the honorable apex court of this land.
what is the difficulty?
He's on his legs in another court, my lord. Yes.
Lord,
We'll have it, let him have your colleague has a problem.
Lord, immediately after vacation,
May be fixed. Date
Please.
may be fixed.
Adjournment is sought on behalf of the council on the ground that the senior is busy elsewhere. Though the submission is, though the request is opposed,
please.
in the interest of justice, re-notify all.
Interim order may be.
Interim order, if any, to continue. Give it in October only.
Lord, immediately after vacation, my lord.
Sir, 28
Since
to 10.
2013, my client is suffering.
Note the date.
28 to 10, sir.
Please.
28 to 10.
My lord, serial number 41 also.
Interim order, if any, to continue. Which one?
Serial number 41 also. I am for the petition.
Yes. Who appears for the other side?
Miller.
Who is mentioning?
I am petitioner. my lord.
Request for adjournment is made on the ground that the arguing counsel is in personal difficulty, which is the prayer is not opposed, adjourned to.
14/11.
You said 41, na?
Please, my lord. SN Prashant Chandra.
14/11, sir.
Okay.
Serial number 1. Serial number 1.
For the appellant.
4 weeks to
Please.
remove the
Serial number
objections.
1 and serial number 17, my lord, arise from the same order of the learned.
18 also.
Serial number 16, my lord, I'm sorry. Serial number 16 is listed for orders and IA,
Both are same,
same.
but who appears for the respondents
My lord, notice has not yet been ordered, my lord,
in both the matters?
in both the matters.
Just 4 weeks to remove office objections. And 16 also simply separately say re-notify all.
Please.
Okay,
My lord, there is one more writ appeal, my lord, arising from the same order. May I be permitted to pass on the number?
you should file an application.
Sure,
That
please.
would be better.
I'm grateful.
Separate order in 16.
28/11, sir.
Great.
16 also same. sir. Serial number 2.
Yes, Mr. Gunjal,
John.
This matter, my lord,
we do one thing.
I'm only seeking for a direction.
Now, who is the respondent? You appear for the, ma'am, you are the respondent, come forward. You appeared before the lower court?
No, sir. I mean, before this? No, sir. Last time. I filed.
So you appeared before the court, before the guardianship court?
No, sir.
No, it was filed on 14/6.
Yes, sir.
You appeared.
Yes, yes, sir.
Just ask him to come here.
Appear again, sir.
You appeared. See, we can do it.
So they've given the time, sir, for objection.
Just Mr. Beliappa, just ask her, is she sending the child to the school?
So we don't have how, I mean, it is 30 kilometer to travel.
ಮಗುವನ್ನು ಶಾಲೆಗೆ ಕಳಿಸ್ತಾ ಇದ್ದೀರಮ್ಮ?
ಅದೇ ಸರ್ 30 ಕಿಲೋಮೀಟರ್ಸ್ ಇದೆ ಸರ್. ನನ್ನ ನಮ್ಮ ಮನೆಯಿಂದ ಅಲ್ಲಿ ಕಳ್ಸೋದಕ್ಕೆ ಮಗುಗ್ ದಿನ ಬೆಳಗ್ಗೆ ಕಳ್ಸೋದಕ್ಕೆ ಆಗಲ್ಲ. ನನ್ನ ಮನೆಯಿಂದ ಓಡಿಸಿದಾರೆ ಸರ್ 12 o'clock ಮೇಲೆ ಕೀ ಕಿತ್ಕೊಂಡು.
ಮತ್ತೆ ಎಲ್ಲಿ ಶಾಲೆಗೆ ಹಾಕ್ಬೇಕಂತ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಅದೇ ಕಳಿಸ್ತೀನಿ, ಟೈಮ್ ತಗೊಂಡಿದ್ದೀನಿ ಸರ್ ಸ್ಕೂಲಿಂದ. ನನಗೆ ಮನೆಯಲ್ಲಿ ಹತ್ರ ಮನೆ ಮಾಡ್ಕೊಂಡು
ಈಗ ಮಗುಗೆ ಎಷ್ಟು ವರ್ಷ?
6 years, sir. ಸರ್ ಇವಾಗ ಸ್ಕೂಲು ಇಲ್ಲ ಮತ್ತೆ No, we don't have any basic accommodation.
Mr. Gunjal,
Please, my lord.
today your concern is only this, that the child is not going to the school.
School, one, my lord, and at least some minimum visiting rights, my lord, minimum.
We'll do one thing then.
Please.
Matter is on 24th before the lower court.
Yes, my lord.
Okay. They have been given time to file reply.
Please.
Surely. So it's a matter of few days. You see, you have to see from their perspective also, from the perspective of the court also.
Yes, my lord.
The court cannot, without a reply, inviting a reply from the other side,
Please.
allow your application for at least interim, the visitation. It was listed on 25th. They have given time. In between, you have holidays also.
Pardon, my lord.
In between, you have holidays also.
Yes, my lord.
The court has given time. They have fixed the date 24th, na?
Please.
Is it 24th?
Yes, my lord.
That's right. So 24th, it is expected the court will hear it and decide your interim prayer also. Getting the point? So we say nothing. You are already there before the court concern.
Please,
So
my
let the
lord.
court decide.
I will place two judgments, my lord. I will leave.
We don't want to go into all these judgments,
No, the
maintainability.
issue is this,
everything.
my lord. Now the child has missed the school for 1 month.
Yes, you have heard the respondent saying, what she says is subject to you seek instruction from petitioner also, you also understand. What is being said is that the school is 30 kilometers away from the house.
Please, my lord. I'll put it this way, my lord. Now the sacrifice should be from the parents. She intentionally takes the child, keeps it 30 kilometers away. This issue, my lord, she should, if her concern, paramount concern of this thing for the child was this thing, my lord, she would have taken the child. It's not 30 kilometers away. It's hardly about 14 kilometers away. 14 kilometers away, she can engage a taxi, come to school and take it back. There is no difficulty. The paramount concern of the child she is sacrificing, that issue has been lost sight.
Yes, one. Now just ask her, does she intend to shift the house?
ನೀವು ಯಾವಾಗ ಶಿಫ್ಟ್ ಮಾಡ್ಬೇಕಂತ ಇದ್ದೀರಿ ಮನೆ?
Another 15 days ಒಳಗಡೆ ಸರ್. ನೋಡ್ತಾ ಇದ್ದೀನಿ ನಾನು ಆಲ್ರೆಡಿ.
ಅದ ನೋಡ್ತಾ ಇದ್ದೀರಿ?
ಬಟ್ ಅವ್ರು ಏನು ಮಾಡ್ಕೊಡೋದಕ್ಕೆ ರೆಡಿ ಇಲ್ಲ ಸರ್.
My client is ready to arrange a taxi every day, my lord.
Just 1 minute.
ಮನೆ ಸ್ಕೂಲ್ ಪಕ್ಕಕ್ಕೆ ಹತ್ರಕ್ಕೆ ಮಾಡ್ಬೇಕಂತ ಇದ್ದೀರಿ? ಶಿಫ್ಟ್ ಮಾಡ್ಬೇಕಂತ?
Because it's still 6 years old, sir.
ನೋಡ್ತಾ ಇದ್ದೀರಿ
ನಾನು
ಅಲ್ಲಿ?
ನೋಡ್ತಾ ಇದ್ದೀನಿ sir.
Searching for some of this, searching for the house. So within 15 days you will look at the
Nearer the school.
near school.
What the respondent is saying is, within 15 days, she will shift her house nearer to the school.
Please, but till then, let the child attend school. He will arrange a taxi every day.
Is the school in progress? Is the teaching is taking place? The school is open.
Pardon?
The school is open. Just ask your client.
No, now he's having a vacation
Till when?
till 14th.
Till 14th, na? So what she is saying is, within 15 days, she will shift nearer the school. We will record that. We will record that. Okay? So in any case, till 14, there is a recess. For the next 14 days, there is no need for you to bother. We will record her 15th day. Just ask her that in 15 days, you will shift.
15 days ಅಲ್ಲಿ ಶಿಫ್ಟ್ ಮಾಡಬಹುದಲ್ಲಮ್ಮ?
ಹಾ ಸರ್ ನೋಡ್ತಿದ್ದೀನಿ ಅದು ಯಾವ್ದಾದ್ರು
So, Mr. Gunjal, she says that within 15 days, she will shift nearer the school. We will record that.
Please, my lord.
Okay?
But what has happened, your lordship may kindly from other angle also. Now 30 days, 45 days, the child would be brainwashed. That's the reason, the father, that's what our courts have taken. Let some visiting rights be given in the.
1 minute, please. Let's be very clear.
Please, my lord.
We are more concerned on the child. We are more concerned with the child not going to the school. We are actually concerned. The proper development of the child is when he goes out, mixes with the other children, there is a proper development. Next 15 days, there is no school now.
Man, 15 days school.
Yeah, till 14th is having.
Till 14th, the school is off.
Yes, my lord.
We are recording her submission that within 15 days, she will shift her residence nearer the school. We will record it. Insofar as visitation, anything is concerned, you will work out before the court concerned.
That is where this honorable court has said, some.
We will not go into that. We will not allow parallel proceedings. One there, one here. We will not allow that.
No, in fact, this court has intervened, my lord. That is one thing. Now we are, what your lordship is discussing, my lord. May I make one submission, my lord? May I make one submission, my lord? I will make an advancing. Let this matter be postponed to the reopening day instead of 24th.
We will not allow that. Where? Before the court concerned?
Before the family court. At least that's some relief to me.
You will file an application before the court for advancing the date.
Advancing the case on the reopening day.
You will file an application. We
Yes.
don't understand. There may be so many people like you there. We will not allow that. You will file an application. The court will decide. We will not decide the board of the court.
Please, the petitioner's father has got the rights, my lord. Entire things are being shut out, my lord. Nothing. Your lordship, he takes.
Mr. Gunjal, 1 minute.
1 minute, my lord. May I make one? The husband was slapped by the father-in-law. The child was taken away. Your lordship, see, under violent conditions, they took the child. Now, she doesn't send the child to school for 30 days. I move the court. I do everything. I pay the fees. I do everything. No, just the father cannot be deprived of his rights, my lord.
So whatever he is telling is, it is not true, sir.
Can the father be deprived of rights? That is my biggest concern, my lord.
Just wait. We will say two things.
Please,
We will record her submission within 15 days. She will shift her residence to nearer to the school. That's one. You are seeking early hearing of that petition which is pending before the court below.
Please, my lord.
We will give you liberty to file an application for advancement of date.
Please.
That's all. We will dispose of this petition. Okay?
Please, my lord.
Yes, say this.
My one, the same, my lord. At least, please, my lord. One submission,
Yes,
one
one.
request, my lord.
Yes.
Let us send the school child to the school after 15. No, instead of straight. Say that two things. One, she will shift near the council. Let me say that I will give you time. You are not understanding.
One this thing, my lord. At least 1 or 2 visiting rights in the vacation, my lords.
We will, Mr. Gunjal, only thing, you are before the court below, the court will consider it. We will say only this.
No, I am requesting this court, my lord. There are 3 important festivals in the meanwhile. At least some time for the father and son to spend together. It's not a humanitarian requirement, my lords. Can she separate the father and son, my lord?
1 minute, please. Who appears for the?
The counsel appearing before the lower court and the family court.
You are the.
Undertake to file, in this case, my lordship, laterwards I am filing Kalat. In this case, there are filed 4 interim applications. In the meantime, the honorable court has been granted for objection in the next month. So in meantime, they are
Yes.
submitted before the trial court and seeking for visiting rights. We stated that we have no objection. In the same day, they come and visit the child. But till date, they are not come.
No, 1 minute. Was there any order of the court below that he will
No,
come
no,
and
no.
visit the child?
No, it's a objections, my lord.
While, please, my lord, this transpired what
They
my
filed
point says,
4
when they are
interim
coming down the
applications.
stairs, when they were coming down the stairs, my instructions are when they
1
were
minute.
Can we get the order today itself, my lord?
We will try, otherwise tomorrow morning you will get it. Oh no, we'll try to give you today.
Please, ma'am, if they request that, I will.
Yeah, surely, surely.
Serial number 3.
Yes, ma'am.
I appear for the appellant in this.
There is
What
a
has to be
connected
done?
appeal in the.
First case not appear for the appellant, 3983 of.
But this need to be heard now.
Yes, my lords,
heard.
we need,
We'll have it.
office objections are to be taken as complied with, because what, they have served copies on us and we have served copies on them. Now it needs to be heard. Maybe,
Both the matters.
please, my lords,
Same or
same.
The learner counsel, senior counsel for the appellant submits that the office objections have been cleared, full stop, registered to,
Fourth
registered,
week of October would be ideal, my lords. Third week, I'm not here.
registered to verify the same.
Only mandamus is that started, not in the end of October. Only.
We'll just give. Re-notify on just whatever is coming, we'll give the convenient date.
After 20th of October.
It will be November only, not in October.
Please, my lords.
Not it is too late, but because it is.
We have to see the board, please.
That is why.
We have to see our board.
Not for the start date.
Sir,
Okay, we'll give the date.
14/11, sir.
Grateful, my lords.
Next,
At the end of October, they said that.
not possible.
Serial number 4. TVS Nayak. Serial number 4.
The office objections be clear.
Regarding council submission, Lordship may kindly permit me to make small statement on what has happened. It is a case pertaining to 8 workmen. They were all before the tribunal. May I request you, Lordship, kindly turn to my lord, I will not take much time. Lordship may kindly turn to page 76, my lord.
What is the submission, Mr. Bas?
My lord, the names of all these workmen, my lord, they are found in the order of reference made by the central government. They are all parties before the tribunal. But nevertheless, my lord, the office objection is that their names are not found in any of the documents. That's all, my thing. Lordship may kindly turn to page 76, my lord, for a moment. Central government reference is names of all these workmen. Whether the management is justified in removing these workmen from the service.
That's the reference.
Yes, names are there. What has happened, my lord? Now, last we can turn to page 75. Kindly go to page 75.
We have seen that.
Yes, K.C. Veerabhadrachari and 7 others.
Pardon?
K.C. Veerabhadrachari is one of the workmen and 7 others. Now, my lord, before this honorable court, in the representation, all these 8 workmen are the parties.
In this appeal also?
Yes, in this case. This is the only obvious subject.
All 7 are party. Why? Who is this gentleman? 8, Krishnappa, there are 8 people.
Veerabhadrachari and 7 others.
No, but the reference was with regard to 8 persons.
8 workmen, yes. 1 plus 7.
Krishnappa is also there. Okay. What is the objection?
Lord, that these names are not found in the order of in any of the documents before.
Where is the award?
Award is, that's page 75 is the award.
Oh, that's the award.
Yes, this award is under challenge to the extent I am aggrieved.
Oh.
Page 76, all the names are awarded.
The learner counsel for there is an office objection that document showing petitioner 2 to 8 were parties in the labor court be filed. Full stop. The learner counsel, Mr. Nayak, learner counsel for the petitioner, has drawn our attention to page 75 to state that the central government has made a reference who are the 8 petitioners whose names are also reflected in the terms of reference. Full stop. If that be so, the objection of the registry is overruled. This petition for preliminary hearing on.
15/11.
Take the date.
Yes.
Sir, 15/11. Serial number 5. Serial number 5.
See, I'll place it before another bench, this matter. Subject to the orders of the Honorable the Chief Justice, list these appeals, list these matters before a bench of which one of us, V.K. Rao J, is not a member on. Subject to the orders of the Honorable the Chief Justice. Just give a date.
13/11.
Next.
Interim
order may be extended.
Pardon?
Interim order may be extended.
Interim order, if any,
Please.
wherever there is an interim order.
Interim.
Interim order, if any, just see the last order.
Great.
Okay. Interim order, if any, to continue.
Serial number 6. 6, Sri Rudrappa.
Complete the office objections will not. In the meantime, my lord, we are also trying to, for the settlement.
Louder. Use
Not.
Like,
I'll comply with the office objections, my lord, on IAS. And my lord, in the meantime, we are trying for the compromise also, my lord, in this matter.
Yeah,
Ma'am, you are appearing for the respondents.
yes, please, one.
At the joint request of the council for the parties re-notify.
A short date maybe the next month, my lord, may kindly.
You will first work it out. You'll have it. Just give a date.
Please, please.
10th of November.
Grateful.
Obliged.
Next.
Serial number 7, party in person, Sri S. Mohan, C.S. Mohan.
In this case, there is a delay of 62 days.
You have to, there are certain office objections, Mr. Mohan.
It has already been overruled by the, and it has been posted for an issue notice.
Is it?
There is an order.
When was the objections overruled?
I have already filed a memo wherein it has been overruled and posted for
We'll just
to issue notice.
This is okay. This is the issue.
File is good, both are there. File. In order sheet it is there.
But there is no order, Mr. Mohan.
There is an order.
Which
There-
date? Which date?
I will give. And it was posted for to hear IA2 regarding condonation of
We'll
delay.
do one thing. We'll record your submission,
Yes, my lord. I will give the date.
but have you filed the typed copies?
Madam,
Have you typed?
Typed copies.
Do one thing, Mr. Mohan.
Yes,
There
ma'am.
are certain translation copies need to be filed,
I have already, that has been exempted.
but you should file translation. We'll have a difficulty now.
Yes, my lord, in this last time itself I have submitted. This honorable court was kindly accepted in, if it is in case, if it is required, at the time of hearing, I will file that. Only one translation copy. Yes,
Okay. If required, we will call for.
yes, my lord. Papers ಇದೆ ನೋಡಿ. ಇದಲ್ಲ. ಇತ್ತಿಗೆ ಬೇಗ.
Respondents have been served.
The order dated is 22/1.
But have you served the respondents?
Yes, I have already served. The respondent is here.
Have anyone followed?
That is dated 22/1/2024.
SP Shrikant.
Orders date.
SP Shrikant.
Order dated 22/1/2020.
Just 1 minute.
Yes.
So no need for a notice has been issued.
Yes,
They have
ma'am.
been served also.
Yes, it has served.
Just say this.
And he has already appeared. Last time he came, he has appeared.
Just say that there is none for the respondent number 1. Re-notify on the council for the parties to file their written submissions. File your submissions.
Yes, ma'am. And another, my humble submission, in respect of the same, this one, another writ appeal is filed. It may kindly be connected. And along with that writ appeal, it may kindly be posted.
You file a memo or an application, then only we will consider it.
Yes, ma'am.
What is the writ appeal number?
1282
Of?
of 2024.
That roster we will not have. You may have to move the Honorable the Chief Justice. We say nothing, just say the re-notify.
1911,
Next.
serial number 8, Srimati Sudha. Serial number 8,
Yes, Mr. Pritish.
I appear as proxy.
What do you want?
Advocate on record, serial number 8. Advocate on record wanted sometime. Any date
The
after.
request for adjournment is made on behalf of the counsel for the appellant. We notify on.
2511,
Great.
serial number 9. Sri Manu.
For respondents 1 to 4, my lord.
File your submission.
Respondent number 5 is to file.
Submissions, the counsel for the parties shall file their written submissions if not already filed.
Yes, ma'am.
Okay, within 6 weeks, re-notify on.
2811,
Much honest.
serial number 10.
My lord, appear for the appellant in this matter, my lord. I pray for some time to take fresh steps to
Let fresh notice be.
issue notice on the answered response, my lord.
Fresh notice be issued to respondent number 18, 26 and 30, returnable on.
2811,
Please.
serial number 11, Shri B.C. Prabhakar.
Let fresh notice be issued for service on the respondent, returnable on.
2911, serial number 12, Shri Ananta Krishnamurthy.
Let fresh notice be issued for service on respondent number 1.
For the appeal.
3911, serial number 13.
Well, it's happy for the petition in this case. The
Respondent
matter is still before the mediation center parties.
The counsel for the parties submits that the mediation process is still in progress.
Please,
Adjourn to
1411,
grateful malice.
serial number 14, Srimati Jyoti.
Mr. Biliappa, you
For the respondent state.
have not filed your status report.
Yes, my lords, a week's time, my lords, will file it, my lords.
Status.
Oh, my lord, what happened, my lord, is that the entire family members, my lord, are in tents.
Hmm.
All the family members, mother, parents, brothers are before your lordship. My lordship, the police have not done anything in this regard, my lord. Casually, they are investigating the matter, my lord. Since 3 weeks, my lord. Okay, my lord.
But what are your investigations?
Please, my lords, it's been instructed, my lords, that the petitioner is an earlier wife of the said missing person, my lords. Now the missing person was residing with her from past 3 months. So thereafter, my lords, he went with the second wife and this family. So thereafter, he went missing, my lords.
But you have seen the allegations.
Yes, my lords.
So what do you say? What are the allegations? You must file your,
Please,
before 14th, you must file your, this thing.
sure.
You want to have your, did you inquire? Did you make any investigation?
Yes, my lords, it's been done. It's been done completely, my lords. We have sought information from FRRO, seeking information whether this person has traveled abroad or not, my lords. As the second wife is in Dubai. So we have sought an information from FRRO, seeking information whether this person is.
The official divorce. He is a
Oh, wow.
divorcee who is the petitioner before your lordship. The allegations are that the detainee was with the second wife
Serial number 15. Nikhilesh Rao.
It's a matter, my lord,
Yes.
where an application under Section 8 of the Arbitration Act was allowed by the NCLT in my operation and mismanagement petition. My lord, what has happened is I filed a company petition alleging certain acts of operation and mismanagement. I'd raised various grounds. The respondents, my lord, filed an application under Section 8. The only ground on which they filed Section 8 was that one of the grounds that I had raised in the company petition forms part of the shareholders agreement, which contains an arbitration clause. So out of the 6-7 grounds of operation and mismanagement that I had raised, their application, my lord, said one of them is arbitrable, which is also not in my respectful submission. But there was no averment at all in the Section 8.
You also file arbitration petitions.
Please, my lord.
You also filed arbitration petitions for appointment of arbitrator.
No, I have not filed any arbitration petition.
Previously,
No.
no,
So
they have filed it.
they had filed it, my lord. They had filed it and there is an arbitrator appointed, my lord.
But tell us, you see, come to page 184.
Please.
It's wide enough. Your whole argument case is only on merit.
No, my lord.
That's right. We'll show you. Come to page 184.
184 is the dispute resolution clause, my lord.
See the arbitration clause.
I'll read it out, my lord.
Read it.
If any dispute arises between the parties hereto during the subsistence of this agreement or thereafter in connection with the validity, interpretation, implementation, or alleged material breach of any provision of this agreement, or regarding a question, including the question as to whether the termination of this agreement by one party hereto has been legitimate, the parties hereto shall endeavor to settle the dispute amicably. The attempt to bring about an amicable settlement is considered to have failed as soon as one of the parties hereto, after reasonable attempts, which attempt shall continue for not less than 15 days, gives notice thereof to the other party. All disputes, controversies, differences of opinion arising out of or in connection with this agreement, or for the breach hereof, which cannot be settled amicably by the parties hereto, shall be settled by arbitration in accordance with the Indian arbitration.
You have seen, read this sentence once again.
Yes, madam. All disputes, controversies, or differences of opinion arising out of or in connection with this agreement,
That's right.
or for the breach hereof.
Right?
Please.
Everything.
Everything, provided it is covered by this agreement.
Obviously, it talks about agreement. You read it.
I'm not saying, my lord. My case is that the issues of oppression and mismanagement that I had raised before the
Not only that, you have asked for your nominee arbitrator to be the nominee to be part of the board, which they did not accept. It's only everything is flowing from there.
No, my lord. I will point out from the amendments that I made in the company petition, my lord.
I don't see any reasons. There is an arbitration clause that it has to go there.
No, but I'll point out the judgments also, my lord. I'd raised 1, 2, 3, 4, 5, 6 grounds. May I simply point out the amendments that I made in the
Come to
company petition, my
11.2
lord?
once again.
Please, my lord.
Come to 11.2 clause. 185.
Yes. All disputes,
controversies, and differences of opinion arising out or in connection with this agreement, or for the breach thereof, which cannot be settled amicably hereto shall be settled by arbitration.
Please, my lord.
Your whole case is, please appoint this gentleman on the board, which they did not accept. Everything flows from there.
No, that is what the NCLT says, my lord. Those are not the only allegations that I made in the company petition.
Right. We are concerned with the arbitration clause. The moment there is an arbitration clause which encompasses all disputes and differences, it need to be decided by the arbitrator.
Correct, my lord. The arbitration clause has to encompass all disputes. That is the requirement. In my case, that is not applicable. I will point out from the company petition. There is no clause in the shareholders agreement which covers this. The issues that I have raised in the company petition are not covered by the shareholders agreement.
The issue raised in the.
I will point out, my lord. Page 223, my lord.
Yes. See the prayers. Come to the prayers of your petition.
I'll come. declare that the affairs of the respondent company have been conducted in a manner of
C. Come to prayer C.
Please, my lord. Prayer C is direct respondents 1 to 6 to appoint so and so as the nominee director. My lord, this is one issue.
Forget
The
it.
issue
One
of
issue, two
appointment
issue,
of director is one
We will
issue.
not segregate it. This is the cause. It flows, if your nominee arbitrator was there, there would not be in any case of, mismanagement, operation, nothing of that sort.
No, my lord. No,
Very well, if you want
because
to
my
say
lord,
no.
if I may just request my lords to kindly go to paragraph 19, my lord, of my company petition at page 223. My lord, this is where I've raised the grounds. Respondents 2 to 6 have caused Avigo to sell. Avigo is one of the other shareholders of the company, to sell its shares, thereby becoming majority shareholders of the company. The petitioner, having rescinded its offer to exit the company on account of the conduct of respondents 2 to 6, is now a continuing minority shareholder of the company. As a continuing shareholder of the company, the petitioner has certain rights in the management of the affairs of the company, such as nominating a member on the board of directors. As per the terms of the articles, respondent numbers 2 to 6 are required to facilitate the same. My right, my lord, flows from the articles of association and not from the shareholders agreement. The petitioner had from time to time in the past exercised its right and had appointed its nominee on the board. Currently, however, no nominee is on the board. Further, the petitioner, having noted serious lapses in the management of the affairs of the company, had requested for the petitioner for his nominee on the board. In this regard, the petitioner had issued 2 letters dated so-and-so, requesting the company to convene a board meeting to appoint the petitioner's nominee, Mr. So-and-so, as a director. It is pertinent to mention that the petitioner is entitled to have its nominee appointed as a director on the board in accordance with its right under Article 13B of the articles. However, in spite of repeated requests, despite the issuance of appointment letters, the board has not taken any action to appoint Mr. So-and-so as the director on the board. Such an act amounts to grave disregard to the rights of petitioners in the company and thereby constitute acts of oppression. Further, during June 2017, it came to the petitioner's attention that the company's board is contemplating creation of the first pari passu charge over the fixed assets of the company. First pari passu charge over the current assets of the company without prior approval of the petitioner, which is required under the articles. Under 2 term sheets produced by respondent numbers 2 to 6, in their petition before the Honorable Tribunal, it is evident that under the first transaction, Innovator Traders Private Limited issued a term sheet to respondent number 1 for a term loan of 10 crores to repay its existing debt. And for the same, one of the conditions of the term sheet was that Innovator shall be secured by first pari passu charge over the fixed assets of Rhinak, that is respondent number 1. First pari passu charge over the current assets of Rhinak. Then one more transaction, my lord. And the second transaction, Innovator Traders Private Limited issued a term sheet to fund modular cold rooms, which is the respondent number 6, for a term loan of 55 crores to purchase fully paid up equity shares of Rhinak from investors. And for the same, it was one of the preconditions of the term sheet that Innovator Traders Private Limited shall be secured by pledge over 77% fully paid up equity shares of Rhinak. First pari passu charge over the fixed assets of Rhinak. First pari passu charge over the current assets of Rhinak. Copies of term sheets are produced. The petitioner is also aware that a sum in excess of rupees 25 lakhs has been paid by the company as commitment fee for the purpose of raising debt. Once again, no prior approval of the petitioner has been obtained. Such a spending is admitted by respondent numbers 2 to 6 in their pleadings before the Honorable Tribunal and so and so. It is specifically admitted by respondent numbers 2 to 6 that the company has paid to Pyramid Finance a sum of rupees 25 lakhs towards the term sheet received. The same shows that such a payment has been made without specific consent of the petitioner and presumably of Avigos. Such a payment made is in direct violation of Article 20. It is pertinent to mention that Article 20 of the articles, no action may be taken or resolution may be passed by the board without the affirmative vote of all invested directors in respect of the matters set in Article 20 and Clause 6.112, unless prior written consent has been given by the investors prior to the relevant meeting, or such consent is specifically waived in writing by the investors. These matters include the following: any significant change in the liability structure that is greater than 25 lakhs, in the case that is 25 crores. Then, my lord, we extract the clauses. It is also clear that in any event, one of the matters set out above or such other matters forming part of affirmative vote items under the articles is sought to be given effect to by the board without the prior approval of the petitioner, the same shall be invalid, illegal, and would tantamount to criminal breach of trust and so and so. Therefore, my lord, all of these allegations
which are violative of Article 20 of the Articles of
Come
Association.
to paragraph 15.
Please, my lord.
Now read that paragraph and what is the effect of this paragraph?
It is submitted that all the above mentioned agreements, SSA, SHA, and SPA, entered into between the parties provided for arbitration as a mode of resolution of disputes. However, knowing fully well, my lord, if I may request my lords to kindly go to the previous two paragraphs also, my lord.
Yes,
Paragraph 13 onwards, my lord.
yes.
This talks about a company petition that was filed by the respondents. Kindly see the reliefs that are sought therein, my lord. Direct respondent numbers 2 and 3 to sell their shareholding for a total sale consideration of so-and-so to so-and-so as per the terms of the share purchase agreement dated so-and-so.
Now
this
tell
shared
us-
person-
Tell us, come to the prayers of this.
Please, ma'am.
Now, come to relief A.
Please, ma'am.
Okay. Now, relief A, B relates to all those three agreements, share purchase.
The reliefs that I have sought, my lord, at page 228,
That's right.
No.
We are,
it does not, my lord. That is my respectful submission. Kindly also come to relief E, my lord. Declare all the transaction done by respondent numbers 2 to 6 on behalf of the board of respondent number one company without the express consent of the petitioner and in the absence of nominee director of the petitioner as illegal and order restoration. Now, the
But-
first part,
no, but
let us go by the case that they have pleaded. Let us assume for a moment that appointment of directors is arbitrable without the express consent of the petitioner, that is under Article 20 of the Articles Association, that is not covered by any of the agreements. Now, tomorrow, even assuming I go before the arbitrator will not have the jurisdiction to give me this reliefs.
where is the objection taken in reply to section 8?
The objection, my lord, is that Annexure C, my lord, page 201.
Page?
201.
Where do you take this objection?
My lord, paragraph 3. At the outset, it is submitted that the application is liable to be dismissed for non-joinder of necessary party.
Non-joinder, forget non-joinder.
No, the next sentence itself, my lord. The next sentence. Further, the rights of the respondent is being asserted in relation to its position as a shareholder of the company. The present dispute is not a contractual dispute, but arises out of a serious breach of legal and fiduciary obligations of the applicant.
See what really governs the relationship. It's all these three documents which govern the relationship. So anything, any dispute with regard to the company, be that as a shareholder, be that as a claim for directorship, everything will flow from there only.
My lords, what the courts have held, a claim for appointment of director is something that is within the exclusive domain of the NCLT. Even assuming there is an arbitration clause, it is not an it cannot be decided by arbitration. That is the view the court have taken, my lord. I have judgments to that effect also. But it is not.
Was one judgment.
Please, ma'am.
See, this submission you are making
Please.
in the context of operation, mismanagement. That cannot be arbitrable. That is not an arbitrable issue.
Yes.
That's what you are pointing. It's exclusively the jurisdiction of a company court or NCLT in this case.
Yes,
That's
my
the
lord.
argument you are making.
Yes, and they have not even pleaded that some of the allegations that I've raised in the company petition are arbitrable. Their case is that issue of appointment of director is arbitrable. What about the issue of
You show your.
my lord, when there are
No, you are
multiple-
defending the application.
No, I'm
They
not.
filed it.
They filed it. It was allowed.
They have filed section 8. You were defending section
Yes.
8. Yes.
My lord, what happens
when there are multiple grounds raised in a company petition, and one of the issues is arbitrable, can it be bifurcated? My lord, the Supreme Court says, no, it cannot be bifurcated.
But where are all these arguments taken? Tell us, we want to know that.
My lord, it's detailed in the objection statement, my lord. In fact, the NCLT in its impugned order, my lord, recognizes all of this.
The NCLT only, it sums up the whole thing in 2 pages. That's all.
There are absolutely no reasons given, but all the arguments that I addressed, my lord, they're laid out.
These are all arguments. They have reproduced everything.
No, this is
We
what
want
I
to know on the arbitrability issue,
Please,
which
my
is the subject matter. Now tell us one thing. The previous litigations where arbitrations petitions were filed were also in the similar nature. There was also a company petition filed, that is 17 of something.
They filed it, they withdrew that, my lord.
What was the company petition filed for?
My lord, that is the relief that I pointed out, my lord, in my company petition now, which I just read out, my lord, at page 220. They, my lord, want me to sell my 16% shareholding to them under the shareholders agreement.
What is the date of the impugned order?
1st April, ma'am. 1st April 2024.
Why are you coming now after so much time?
My lord,
What happened thereafter?
I have not initiated arbitration, my lord. I am not part of.
Have they initiated?
My lord, their arbitration is going on, my lord, by virtue of the Supreme Court order.
Pertaining to this order, that's a different argument.
No,
That's a
pertaining to
different-
this order, no. Their arbitration has been going on since 2023 April.
But because you were the petitioner, you were the claimant, they did not initiate it because there is no dispute insofar they are concerned. The dispute arises because of you. You are only.
My lord, let me, factually, my lord, this is what happened. They, my
No,
lord,
tell us one thing. You did not invoke arbitration.
no.
They would not in any case because they have no dispute. Because they had not approached the court.
Yes.
It's only you approached the NCLT under the
Please, my
petition.
lord. May I, my lord, request to kindly go to page 235. Simply because.
No, you show us from this judgment, where does it say insofar as the subject matter of the NCLT is concerned, they are not arbitrable?
My lord, may I point out
Because it's
the
an exclusive jurisdiction of NCLT or a company court, and as such not arbitrable. Where does it say?
Please, my lord. My lord, before that, may I point out the order of the Supreme Court in the arbitration petition that they had filed?
That we have seen.
Yes.
But we are not concerned with that petition. How are we concerned there?
No, there were 2 petitions, my lord. One was the arbitration petition that they had filed, and one more SLP that they had preferred, which arose out of the company petition that I had filed. Both were clubbed before the Supreme Court. At the time of passing of the final order in the arbitration petition, the Supreme Court, they, my lord, made a statement before the Supreme Court that my dispute as well as their dispute be referred to arbitration. The Supreme Court refused and said, I'll hear the SLP separately, and it heard the SLP separately and then directed the NCLT to hear the Section 8.
But the Section 8 need to be heard. That's the direction of the Supreme Court.
Yes, hear and dispose it off in accordance with merits.
So we are concerned with Section 8 order only.
Only, my lord.
Now, where is the relevant para? Come.
Please, my lord.
This is only on bifurcation, you're saying.
No, judgment number 1 is on bifurcation, my lord. If there are multiple issues and even one of the issues is not arbitrable, then everything has to stay before the court. That is Sukanya Holdings, my lord. There's one judgment number 7, my lord. It's a judgment of the NCLAT. It sums up all the Supreme Court and the High Court judgments and comes to a finding. Page 89, my lord.
These are based on Boozle and everything.
Yes.
No, we want to know in the context of Company Act.
Yes, my lord.
On that, and more so, the petition which you have filed could not have been referred to arbitration.
Please, my lord. It flows from this. I'll read it out, man. Page 89, para 7. The distinction in law between disputes that are capable of arbitral resolution and those that are not constitutes the question of arbitrability. Some fell for consideration of the Honorable Apex Court in Boozalan. It held the term arbitrability has different meanings in different contexts. The three facets of arbitrability relating to jurisdiction of the arbitral tribunal are as under. Whether the disputes are capable of adjudication and settlement by arbitration, that is, whether the disputes, having regard to their nature, could be resolved by a private forum chosen by the parties, the arbitral tribunal, or whether they would exclusively fall within the domain of public fora courts. Whether the disputes are covered by the arbitration agreement, that is, whether the disputes are enumerated or described in the arbitration agreement as matters to be decided by arbitration, or whether the disputes fall under accepted matters excluded from the purview of arbitration agreement. Whether the parties have referred the disputes to arbitration, that is, whether the disputes fall under the scope of the submission to the arbitral tribunal, or whether they do not arise out of the statement of claim and the counterclaim filed before the arbitral tribunal. A dispute, even if it is capable of being decided by arbitration and falling within the scope of arbitration, will not be arbitrable if it's not enumerated in the joint list of disputes referred to arbitration, or in the absence of such joint list of disputes, does not form part of the disputes raised in the pleadings before the arbitral tribunal. Then, my lord, there's some discussion on that. Paragraph 36, my lord, there in Booz Allen. The well-recognized examples of non-arbitrable disputes are disputes relating to rights and liabilities which give rise to arising criminal offences, matrimonial.
We are not concerned with these.
Please, my lord.
Insolvency also we are.
Insolvency and binding up matters, my lord. So what happens in a section 241, 242 matter, my lord? The NCLT has to come to a conclusion in order to grant the reliefs that are sought, that it is just and equitable to order binding up of the company. So the courts have taken essentially 241, 242 jurisdiction.
Prayer, na, in the petition. Was it your
No,
prayer?
I don't have to ask for that prayer, my lord, in a 241, 242. If the NCLT comes to a conclusion that I have proved my case, it has the power to order binding up.
Where is your reply stating so on the issue on the maintainability of section 8 itself? That this petition, this application is not maintainable because this is not arbitrable. Have you taken, where have you taken?
I'll show. My lord, paravise responses.
See,
at page 204, my lord.
Page
204.
You know, the better paragraph for you is if you see paragraph 42 of this judgment.
I will, yes. The Haryana Telecom one.
That's right.
Yes. After referring to Booz Allen and the Haryana Telecom, my lord, at paragraph 8 is
Just say that issue notice. Returnable on. Just say give it in November.
my lord, there is one office objection, my lord.
What is that?
That respondent number 6 is made a party, but it was not a party in the impugned order.
See, we possibly may not be in agreement on that. When the company petition was filed, respondent number 6 was a party.
Yes, my lord.
That's all. See, this is only an application in that petition.
That's correct. They ought to have made respondent number 6 a party, my lord.
There is no need. The respondent number was 6 a party in the company petition.
Yes, my lord.
That's enough. This
That's
is only
correct.
an application in that petition.
Please, my lord.
And even that objection was taken that the company was not made a party. We think that that's a very, in a sense, that a frivolous objection.
Yes, please, my lord. My lord, I've asked for an interim relief, my lord.
No,
What had
not like
happened in this, my lord?
Please serve them. It's
No,
an
I
order.
will serve. Since 2017 to 24, my lord, I had an interim order in my
We
favor.
will, April order pass, we are in August, October.
I understand. There
That's
is
right,
some-
you will only serve them. November.
2611. Seal number 16 adjourned, 17, Suraj Naik.
Lords, in 17.4, I appear for respondents 4 to 25. I have a very limited submission to make, my lords. Your lordships have passed an order on 13/3/2024, which may kindly be seen. By this order, your lordships were pleased to record the consent of the learned senior for the petitioner and order, my lords, that though the petitioner's vacancies be not filled, the counselling may continue. The second last paragraph, my lords, of the 13/3 order, having regard to the said submission of the learned senior counsel, it is clarified that the state shall proceed with counselling.
Which order you are reading?
3/2861.
My lords, 13/3/2024.
Yes.
Please pardon me if I'm, yes, grateful, my lords.
Yeah, we can.
13/3, my lords.
Yes.
Page 18.
Grateful. As far as these petitions are concerned, it is submitted by the respective counsel that there is already a protection order issued by this court, which is in force. Learned senior counsel submits that though there is a protection order in force, a further observation may be made by this court so as to direct the respondents to proceed with counselling. Shri Nayak produces a copy of the interim direction court in a similar petition that is extracted. Then, my lords, pointing out to the said order, the learned senior counsel submits that the observation made in the aforesaid writ petition may be carried in these petitions as well, though the state may be permitted to conduct the counselling. Having regard to the said submission, it is clarified that the state shall proceed with the counselling. However, the said counselling process shall be subject to the result of these petitions. What has now happened, my lords, is when the matter was listed before your lordships on 23/9/2024.
Yes.
That counselling of these. Now, my lords, see of the.
No, let's see that order, Mr. Sondi, which we have passed. The one which we have passed the
is
order.
required to go on. Please, my lords. 23/9.
Yeah, let's see that order.
Grateful.
Yes, sure.
This is
It's not there.
the order on WP 28614.
What we recollect, what was said was that they are now going ahead and making appointments or the counseling. That's where we have recorded the submission of the learned AG that shall not fill up the post from which the petitioners have been displaced. To the extent the number of petitioners have been filed, this petition
vacancies would not be
filled. So, to the extent your vacancies are concerned or your positions are concerned, they are not filling it up.
My lords have.
Can you hear us? We can't
We are
hear
the respondents. Lordships.
We are sailing with him also, my lord.
No, we just want to know why this, what was the memo moved? Who moved the memo?
I moved the memo, filed an IA, my lord, for directions. My lord, Mr. Sondi?
What is the IA number? Let's see that IA,
3 of
because we just considered this only on the last date. Let's
3
see
of
the
24
application.
in 28614, 3 of 24 is the IA number.
Is it in 1464?
28614, my lord.
286?
17.4.
17.4. Let's see that. Now, what is the prayer you have sought in this?
But all that we are saying, my lord, is that counseling be conducted in respect of these respondents. My lord, we concede that the posts not be filled up. All that we are saying, my lord, is counseling is to be conducted in respect of other candidates at this juncture. That, my lord, that counseling be conducted in respect of us also.
What is the use? Tell us.
My lord, what will happen, my lord, is that, my lord, if counseling is not conducted at this stage, I will lose the, my lord, opportunity to choose the place of preference. I am in the select list.
No, tell us one, how is it going to prejudice you?
My lord, I will, with counseling, my lord, is, my lord, gets to choose, my lord, one stage of, one's place of work.
That we can work it out once the final disposal takes place.
Lord, all vacancies.
That is subject to any orders to be passed. Even the court has said so. The earlier order which Mr. Sodhi has read,
Yes.
it says subject to outcome. So that takes care of everything.
In fact, the court has said, my lord, counseling be conducted in
No,
respect of.
in fact,
In other cases, my lord, counseling is permitted.
that
But that is what
order
is saying.
direct,
The same order be extended to these persons also. Let there be a counseling, but no appointment order.
Please.
What happens, my lord? There are
I
several.
want to know what is the benefit of
I'm
counseling.
submitting, my lord. There are several vacancies, my lord, across the state. Lord, if counseling takes place, my lord, for that particular vacancy in that particular town. Lord, if all vacancies are filled up and I will be the person, Lord, these 18 persons, my lord, who are competing are the last person. My lord, they will be left with, my lord, the vacancy.
The choice gets
Yes.
effected.
Therefore, my lord, we are saying, let there be a counseling. We will participate. Let them not give an appointment order.
But tell us one thing. Okay, very well. That's well taken.
Yes.
But tell us one thing. Counseling takes place, you choose X place.
Yes.
Hypothetically.
Yes.
Hypothetically also think that you may not succeed.
Yes.
What will happen then to that vacancy of that place?
My lord, if the petitioner succeed, my lord, they will go there.
No.
Then they see, if you are seeking a benefit of counseling,
Yes.
they would also be seeking the benefit of counseling. They would say, you also give counseling so that I am secured of that place, at that place.
Lord, your lordship would appreciate, my lord. There are 1,000 and odd posts, my lord, which are required to be recruited. Just for the sake of, my lord, this 12 person, my lord, 18 persons, my lord, the entire, my lord, the process of counseling, my lord, will get stuck. And we will be the person, my lord, who will be deprived of our choice. What we are saying, my lord, is let there be a counseling. My lord, my lords may, at the final stage of the order, my lord.
Let's ask the, what do you say?
Lord,
Let's ask him. Let's
Please.
ask the.
Please.
The final select list minutes was stayed by this honorable court and then restricted minutes to the petitioners. And court had passed an order that the post from which the petitioners have got displaced in the earlier provisional select list where they were there shall not be filled up. So on the basis of that, minutes, we have proceeded minutes with the final select list was there. We have gazetted the final select list.
So you have kept those vacancies intact insofar they are.
Because on the last date of hearing, the application was by the petitioners stating that we have violated the interim order. My lords, having heard me and having recorded my submission, have disposed of the die. Now, this is by the persons who are in the who will
select list.
who are in the select list. Now, my lords, if the final select list, my lords, has to be gazetted, we have gazetted that excluding the petitioners herein. And thereafter, my lords, appointment orders are issued. After you get an appointment, you enter into service, then the right to choose a place arises.
Okay.
So
You will be giving appointment letters to these applicants who have filed this application?
No, my lords, there is no appointment order as of now. They're outside the gazette. They're outside, my lords, the final select list has been gazetted by excluding the persons, my lords, who are affected by the interim order. So the the applicants herein are not part of the gazette.
Okay.
So therefore, my lords, what they are seeking is that we want to participate in the counseling because tomorrow, if suppose I succeed, the right to choose a place will be deprived. Lords, one subject to what the court might say. Lords, without an appointment order, they cannot actually be permitted to.
They can participate in the
Now,
council.
lords, by virtue of a court order, my lords, if my lords say that notionally they can participate in the counseling without an appointment order, choose a place. But then again, if suppose this gets delayed.
Yeah, we got
then-
it. But tell us one thing.
But that's the court's order in 1464, my lord.
But the
33-24.
counseling presupposes an appointment letter.
Yes.
Now, the issue is whether you should be appointed or not. That's the issue need to be looked into.
Our name is there, my lord, already in the select list.
But that's right, but the selection list is under the litigation.
Lord, the appointment order is the only, my lord, is required to be done. My lord, that is, if, my lord, in pursuance of the final select list, my lord, I am entitled for an appointment order. My lord, that appointment order is also, my lord, is kept in abeyance because of the interim order granted by this honorable court. My lord, the next stage of, my lord, after the appointment order is issued, my lord, counseling is there. Lord, let the counseling happen. But let me not report for duty, my lord, in pursuance of the appointment
You will
order.
not.
Otherwise, my lord, I will be left with, my lord, the leftovers, my lord, in the.
See, you have, one, let's be very clear. You have to cross the first hurdle of getting an appointment.
No, but that
That's
is-
the first.
No, that is there, my lord. I have already crossed it, my lord. My appointment is.
Then
my
why
lord,
did they keep your appointment in abeyance?
just to, my lord, protect the
Right.
interest of those persons. They are not in the select list.
Very well, let's assume, put it like this. If they don't succeed, you would get it.
Yes.
Let's assume.
No, my lord.
Yes.
No, my lord. Mere inclusion in the select list does not guarantee a right.
What
of
we are
appointment.
saying is this, maybe.
So
Suppose
therefore,
you were not to succeed in this petition.
please,
What is the effect on them?
let's whether they will get appointed, my lords, is something, my lords, is futuristic. Today, my lord, sitting
They
here,
were not to succeed.
their
They
name
are
is in the select list.
today.
Whether they get appointed or not is a
So,
different issue.
tell us one thing.
The petitioners will not succeed. They
We will be
not-
in the.
These people will have to be appointed. It is only
Oh,
because
right.
of
That's
the-
why, if they don't succeed, they will be
They will
appointed.
be appointed. They will be appointed.
Okay, okay. So if they would be appointed, then we will see.
If-
See, I think then we will work it out on that.
Please.
Then what will happen? Suppose for a moment you don't succeed, even though you underwent a counseling.
Lord, let the final order, my lord, be passed, my lord, permitting them to, my lord, redo the entire counseling.
The entire select
Entire
list gets-
counseling can be done, my lord, if subject to the final order of this.
How many people whose appointments is not under contest? How many are there? They have been given appointment letters?
My lord,
Lords, we have. Lords,
You're getting, what we want to know is,
Please,
there are people whose appointment is not under challenge at all.
please,
They will be given appointment letter,
please, Lords. They have been,
but you are not giving appointment letter to those people
please.
where this litigation is pending.
Where this litigation is pending, there is one other petition, Lords, where two subjects, Lords, we have also not gazetted. That is botany and zoology. That relates to a different petition. That is a different petition.
Better would be, we will work it out. The court has said subject to outcome. Your rights, everything can be worked out. What is there? How many vacancies are there?
Lord, on the basis of an IA, my lord, your lordships have said, my lord, that counseling be conducted in respect of us also. Kindly
Where do they say?
kindly
See,
see
if there is an order, there is an order.
Kindly see order dated 13/3/24, my lord, in
Let's see that.
WP 1464.
my lord, may I just pass on, my lord, the various order, my lord, passed in all these petition.
Let's see.
In one compilation, my lord, so that lords need not look into the
Page
other.
18 of my
Court of-
IA, my lord.
Which number you said, which date of the order?
Date of the order is 13/3/24 in WP 1464, my lord. Page 18 of my IA, next the order.
13/3.
In this compilation, my lord, page number 5.
We will not fill up the post of the petitioners.
13/3/24.
Page number 5 may be seen, my lord, in the compilation. All the orders are there, my lord, made in different petitions.
But how would you say in view of this order?
Lords, this order has to be read, Lords, on 13/3/24.
Hmm.
After recording the submission, a further observation may be made.
See,
by the-
because the court say having regard to the submission of the learner, it's clarified that the state shall proceed with the counseling. It doesn't make any distinction.
Lords, having regard to the submission of AAG, just in the preceding paragraph, your lordship should note the observation made. Fill up. There is an observation that Within I'm not courts. supposed to fill up. Yes.
without filling a right to counsel, to be subjected to counseling, my lords, is if you have an appointment order. But my lords, the state is open to any, my lords, working out, my lords, with regard to if these persons are permitted to counseling, to participate in the counseling, without an appointment order, and their places will be kept vacant. They're
But
only-
why didn't you clarify to the court, look here, that without being an appointment letter there, how can there be a counseling?
No, my lords, this order, my lords, has to be read. My lords, there are multiple orders in different matters.
This is the
There the
latest
court
order.
has, my lords, the first order is this, stay of the final select list. Then it got clarified that stay is restricted to the petitioners in the petition. Then, my lords, the state can also proceed with the counseling. My lords, if all the three orders are read together, what it means is that the final select list can be operated excluding the places from which the petitioners are displaced. And the counseling, my lords, is the next step insofar as giving an allotment of the posting. It's only about a posting. Counseling is for the purpose of posting. I'll be able to show all the vacancies. The person who is higher in the seniority list, in the select list, my lords, will have the choice, my lords, of the entire.
Their apprehension is this,
They can be permitted, my lords, insofar
they
as.
want X place, they may not get X. That's their apprehension.
Anyway, they don't have a right, my
Malad,
lord,
kindly
to
see
say
the
that I
paragraph
want a
before,
particular
Malad.
place.
And
Now,
make
kindly
this-
see the paragraph preceding.
Lords,
My lord, would your lordship bear with me? Let's, the issue is pertaining to reservation of 371J. Let's, in my petition, the selection is about 10,000 teachers. The displacement of number of teachers, as against 10,000 would be about 3,647 teachers. If your lordships, were to allow my petition. My learned friend, therefore, my submission is your lordships may finally hear all of us. There has been enough number of modifications of the interim order. Ultimately, if they are given appointment and counseling, my petition is.
How long the counseling takes place?
So my friend may not labor because my friend is talking about the school education first. All of them are about the college. There are two petitions relating to school education. There is no dispute about that. There is a separate interim order. All these petitions are about college education, where the number of posts, there are 6 petitions. 1,452 post were notified. Now, we have gazetted excluding the petitioners and some other interim order that's operating in a different petition, we have notified. If the persons who are not in the select list want to participate in the counseling, the state cannot allow them because as a matter of rule, you must be a person who is appointed to be permitted to participate in the counseling. By virtue of a court order, if they are permitted to participate in the counseling, choose a place, but they will not be given any posting till.
No, we will not. We will not. We are very clear. We will hear it. When is the matter coming listed?
11
was the date.
There is an interim order.
Tell us one thing. How many vacancies are there?
What's the total number of
1,000? How much you said?
1,452.
And what is the number of select list? How many are there? All the vacancies have been shown as select list.
No,
or there are still any vacancies would be left?
No, all the persons have been, the select list includes the entire vacancies. But on account of interim orders, the number of persons who are now entitled to be counseled is less. That's the only thing.
How many are there? How many are there?
Lords, in these petitions, the college education.
Overall.
The interim order is for the benefit of only 18%.
The appointment order that we have gazetted contains 1,001 names.
In the counseling.
In the counseling.
How much would be left?
451.
And how many litigants are there before us?
In this batch of petitions, the petition.
In all the matters.
In all the 6 matters, it is total 18 petitioners.
That's all.
That's all.
But there are 2 other subjects where relating to botany and zoology.
So as against 18,
please, Manoj.
There are around 400 vacancies still would be left.
There are 2 different subjects, which is not part of this litigation, where we have not even notified that. That entire subject itself is kept.
No, we are asking, you said 1,400 some vacancies.
Please, Manoj.
1,001 is the select list.
We have to go subject wise again, because different subjects are there.
Subjects are there.
How many people are in 6 matters? If they tell us the subjects, then I will be able to give the statistic. Because it is against counseling is subject wise. It is not because it is not the entire.
See, we'll hear the matters. Better would be that. When is the date of hearing being
When
fixed?
there is an interim order, my lord, operating in favor of those selected candidates, a right is, my lord, given to them, my lord, for counseling. I only request, my lord, to permit them to, my lord, participate in the counseling.
See, the counseling right, we don't want to create a precedent which becomes
there is
good
already,
in future.
My lords have already passed an order, my lord. There is an order we are operating.
Surely with regard to those who are in the select list.
Yes.
Kindly see the
Who would be given appointment.
Yes.
And their appointment is not under contest.
No. Kindly see the paragraph. May I please point out?
Page 5, your lordship will kindly see, my lord, in this compilation.
After the order is extracted.
Compilation.
Yes.
Page 5, your lordship will kindly see, my lord. Pointing out to the said order, the learned senior counsel Madhu Nayak submits that the observation made in the aforesaid writ petition may be carried in these petitions as well. Though the state may be permitted to conduct the counseling. Having regard to the said submission of the learned senior counsel, it is clarified that the state shall proceed with the counseling. However, the said counseling process shall be subject to the result of these petitions. Keeping in view the
stay was only quae, my lords, the petitioners, as your lordship see in the previous paragraph.
Yes. What is
the middle of
Mr. Ratish? Ratish, tell us one thing. Yes.
Intelligence, my lords, to point out. What is the date?
But tell
Lords-
us one thing.
Lords, on the last date of hearing, after hearing me and the learned additional advocate general, your lordships have made an order which probably is not yet uploaded on the website. If any order that is made may run in the face of that order of your
So
lordships.
you can see that order. We'll show you that order. You have that order.
No, it's not uploaded, my lords. That's our difficulty.
Get it?
What is the case?
It's uploaded.
We'll just read that order for you.
The last week.
Last week.
Yes. With the-
Print a copy. Middle of that. That's what I think.
Have you seen that order?
Which one?
See, it says that learned AG who appears for the state submits that the order dated this has been clarified by this court. Clarified by this court by stating respondent's authority shall not fill up the post from which the petitioners have been displaced. According to learned AG, to the extent the number of petitioners who have filed this petition, the vacancies to the post of assistant professor have not been filled.
No, as long as this is kept, my lords, we have no difficulty. But I felt, my lords, any order that may be made today may run in the face of what has been recorded, my lords.
We just want to know.
Yes,
What is being asked is, they are the people. You are secure to the extent your vacancies are secure.
yes.
That's right. They are not filling it up.
No, that vacancies are secured or not is the point of,
That AAG has given a statement. To the extent of the petitioners, they are not filling it up.
no, if it is secured, moment, my lords, it is disturbed, then it will be in the teeth of your lords.
What is the basis for your apprehension? It will be disturbed.
Because of the.
Just here, let's see the second.
No, because of the vacancies subject wise, that is what the learned edition.
That is none of your concern. That
Very
is the
well.
outlook.
No, I'll leave it at
is
that.
their outlook. How
I'll
do
leave it
they-
at
how-
that.
Just 1 minute, please. Now, what is being said is that insofar as the counseling is concerned, now what is being said by this applicant is, what has been said by the learned AAG is that counseling follows the appointment letter. He says the appointment letter has not been issued. There is no question of they being, the counseling is only for the purpose of posting, not for the appointment. So we just want to know. So that's what being said. We just want to know that would that prejudice your case? If yes, in what manner?
That's exactly what we wanted to put it in writing,
Well,
because
do that, you file it. Let them file a reply. How long this counseling will
in
take?
any case, your lords have given a date for final disposal. So your lords may as well decide.
11th of. Let's hear from him how long this counseling would take.
Because counseling might take 5 days. We are not yet notified.
But you have to notify, you have to issue appointment letters,
Please, let's.
then the counseling would come.
Insofar as appointment letters is concerned, it has already been done insofar as the other persons, except the petitioner. The fact that, my lords, the allegation of the petitioners we have filled up, but the fact that these people are here for whom I have not given appointment orders is itself the proof of the fact that I have not given I have not filled up those posts. Now, all they are saying is they want to participate in the counseling. Lords, if 11/11 was the date my lords have given for this matter, there are two options, my lords. In case my lords want to permit them to counseling, that is left to the court.
So we want to hear him because he is the petitioner.
Or my lords, if my lords may take it up immediately after vacation, we can get it.
Yes, can be decided once for all.
But tell us one thing, that order of this court on 13(3) says that the counseling be held subject to outcome.
Quite so.
Will not these people also come within the sweep of that order?
Lords, may kindly see page 4. They have read page 5. Page 4 may kindly. Of the compilation, the passage.
If this is not disturbed, you have no issue.
4, you said 4.
4 moments. They have read 5. Second paragraph. Learned senior counsel so and so produces a copy of the interim order dated issued by
If
the
they have
court
to be counseled
petition.
without being
WP number
appointed.
so and so. He specifically points out to the observation made by the court in WP number so and so
Let the
stating.
matter be heard.
The
what
learned
does it
AG
do?
then submits in the presence of the learned counsel for the petitioner that the order may be restricted only to the petitioners. And so he further submits that they would not fill up the post of the petitioners. Accordingly, the impugned order rendered by the case in application number so and so is stayed. Further, the final select list dated so and so to the post of assistant professor is hereby stayed, and the interim order of stay is confined to the petitioners only. It is clarified that the respondent authority shall not fill up the post from which the petitioners have been displaced. However,
But the only thing is the next paragraph.
next paragraph. My lords, what has happened is court has said that this order we are carrying on forward in this case. Kindly see the next in para 5, pointing out to this order, the learned senior counsel so and so submits that the order observations made in the aforesaid writ petitions may be carried into these petitions as well. Though the state may be permitted to conduct the counseling. So the counseling, my lords, is subject to the observations there. Otherwise, my lords, without an appointment order, I cannot ask them to come. Now, if I issue an appointment order, then my lords, I violate the order. So therefore, my lords, that is how it has to be read with all due respect. Now, as a matter of fact, for adjustment of equities in any case, or my lords.
Okay, we understood you.
Please.
What do you say?
As long as you are protected by your lordship's order, we are looking for that.
Now, you are not filling up those posts to the extent these petitioners are there.
We are not filling up, my lords. In case they are permitted to participate in the counseling without an appointment order.
Who?
The
applicants, not the petitioners.
Not the petitioners. They can choose a place, but they will not be given appointment orders. They cannot go and join.
Very good.
But that can be only by a court order. my lord.
See,
I
we
cannot do
don't
that.
want a situation, you know, what we can apprehend is this. My counseling has been done, I cannot be denied appointment.
So that my lords have.
No, that's something which we don't want to foresee that. Let's be very clear. Equities will be
Lord,
agitated
we
or.
will file an undertaking before this honorable court that we will not ask for equity. We may be permitted to, my lord, go for counseling, my lord, without insisting for an appointment order.
Let's in any case.
See, that's what we have.
We will file an affidavit, my lord, giving an undertaking that we will not claim any
How
equity.
many of you are there?
Lord, only 6 persons, my lord, as far as I am concerned.
Are there?
Yes,
18.
there are others also, my lord, in the petition.
That others can be 1,000 also.
My lord, it is only, my lord, 18%. 18 vacancies, 18%. Total.
Similarly placed like you.
Yes.
And there, but number of private respondents are more. Who have filed applications, my lords, we have to verify that.
You verify it, we'll have it after vacation immediately on 15th.
My lords may pass
Lord,
an order saying that
in any case.
subject to undertaking, my lord, let them participate in
Let's
the.
have a clarity, please. Let's have a clarity. We don't want to pass an order. It leads to confusion, then third party rights, filing applications will lead to more confusion. Let's have a clarity. We don't mind having it on 15th, immediately on a vacation.
Let's in any case, 11th you have posted it for final hearing.
11th of that is
November, Lord, it
away.
is
That
too
is
long.
stuff away. What? They are more concerned on the counseling which is in the process?
Yes.
No.
No, it is yet to be notified.
When?
The date is not yet fixed.
Is there any provisional date fixed?
Not yet.
Not
They're
yet.
yet to
Okay,
do it.
then we'll have it on 15th.
Lordship.
Your lordship consider this also, other than our
Please.
right, the rights of.
Mr.
those
Pratish,
students,
the learned AIG says so and we have said so also. That statement is recorded. The vacancies to the extent of these petitioners shall be kept vacant.
that I'm only, my lord, kindly consider the students, my lord. They may choose a place. Now, my lords, no other candidate can choose that college. Now, my lords, the students of that college, my lords, ultimately are now being deprived because
What?
of the teachers, my lord. In the counseling, if some other candidates chooses and actually goes and report.
See, they must be having a policy. Let's assume that there is only one post at one place.
Yes.
And there are 3 options. Who would get it? The person on the merit?
Yes.
See, there must be something in place.
If
Yeah, they will
choose and
work it
don't
out.
report, ultimately.
Okay, just say that this is an application filed by. Application number is what?
3 of 2024.
Three of 24. With the following prayers. To stop the councils appearing for the parties in this writ petition. Now, this will have a bearing in all the matters.
There are 2, my lord. We have also filed, my lord, in writ petition.
Councils appearing for the appellants oblique petitioners in this batch of petitions have been notified on this application. Yeah. Response, if any, be filed on or before 14th.
Apart from 17.1 that pertains to KPTCL, that is not dealing with it.
It's no connection.
17.1 is KPTCL, 17.2 and 3 is school education. Apart from that, the remaining 6 minors.
Now, which are the appeals with which the people would be concerned insofar as this application?
Except 17.1, 2 and 3, rest of the matters.
Okay, the counsels appearing for the parties in appeal number, except those 3 appeals, exclude those appeals and say these appeals number have been notified on this application. Response, if any, be filed on or before 14th. Okay, list this matter, list this application for hearing on, list this application on 15th, please. Okay. Thank you.
Great.
Interim order work, and this is only an application. The one which we have continued is it's running.
Serial number 18.
My lords,
Yes.
I am appearing in this case.
Yes.
Ma'am.
On 80 days, these cases. Now, we just want to know where were you
Yes.
served? Where were you served in the
My
complaint?
lord, my lord, I have stated very clearly
Huh.
that while the complaint was proceeding, that was a peak corona period, and the address that the respondent had given in the complaint itself, my lord, may have a look if I can show to my lord. That is at page.
Yes. 77.
No, my lord, it is at page. My lord, can we have a look at the order of the district commission also, that is 56. And the complaint is at page 34. Whatever my lord will find it.
Now tell us one thing, this address at Bangalore
Yes, sir.
is also your office?
No, this is our depot.
Depot?
This is our depot, and it is managed by 2-3 staff who are not very qualified, etc. They get instruction from our Delhi office, and accordingly they supply the product.
Now,
And
what
Before
is
that, Bangalore mechanic have that will clarify the position. Page 26, 27, whatever it may make see. 26.
you say that he has been corresponding with you at Noida.
Exactly. That's precisely my point, my lord. He knew very well that
Now, what really made you to come to this court?
my lord, the thing is that after NCDRC order, National Commission order, we have come across a judgment by the Supreme Court which says that the order can be challenged only before the jurisdictional High Court.
in Siddharth Mukherjee case.
Issue notice returnable on.
2511.
My lord, may kindly be pleased to stay the order of passed by the district commission in execution application.
No,
Where
what have-
NBW has been issued and this was stayed by the National Commission also, that is at page 110.
Just show us that
Page 110, may kindly see the National Commission order.
page.
110, 110.
This is in the execution proceedings.
Yes, my lord. Only then we came to know about it.
Now, what happened to these proceedings? Are they still pending?
They are still pending, madam.
No, before the National Commission.
No, before the district forum, district commission.
Where is the order of the district forum?
District commission order is at page, my lord. I'm just.
One, but that's.
That is page 81, madam. 81,
That's all.
page 81.
This is the order.
Yes, madam. This is the only order which we can find out.
NBW.
Issue NBW, that's all. Very crisp sort out.
Good. I think we must follow this. Just say this. But this happened somewhere in 23.
Madam.
Where are the other orders?
Thereafter, the proceeding was stayed by the National Commission. Yes, madam.
Let's see the 20th of May order of 24. Annexure K.
That begins at page 112, 112.
But tell us one thing, even this order was passed somewhere in May 24. We are in September.
Yes,
now, those NBW have not been, has the district forum, district commission reiterated the NBW order?
We don't know, my lord, because after the stay order was communicated, because the stay or this NCDRC order was communicated to us in July itself. And thereafter, we have immediately filed this before the cycle.
Pardon, what did you say?
The National Commission order was communicated to us in July. And immediately we proceeded with filing this petition that is before your lordship. Almost after 2 months.
But you didn't see National District Forum issuing again NBW?
No, we don't find any order, but issue notice is there.
Why we are saying is unless a separate order is there for issue, and that NBW was for the date fixed.
Well,
just serve the notice on them. Let's see.
But my lord, may kindly at least
just say this, the learner counsel for the petitioner submits that with the dismissal of the revision petition was by the National Consumer Disputes Redressal Commission, the execution proceedings initiated by the respondent before the district commission shall get revived. And in fact, the district commission has on 6th March 2023 issued non-bailable warrants to the petitioner, to the managing director, to the petitioner, to the functionary of the petitioner. Full stop. If that be so, if any NBW has been issued by the District Consumer Disputes Redressal Commission. The same shall not be executed till the next date of hearing.
DPO. DPO.
19. Veeresh. Serial number 19.
I appear for the respondent in the matter.
Yes, ma'am.
This petition is filed by the petitioner challenging the order of dismissal of his appeal filed before the CGIT on the ground of limitation, because it is filed beyond the period of 120 days and there.
What are the other petitions? 19.1, 19.2?
They are all pertaining to the different periods.
But all petitions were on the ground of limitation.
Yes,
All
because
three?
yes, because they are all filed with delay, and it is all beyond 120 days.
And did anyone come on the last date? See the appearance? But she appeared. It's only in one. We say that none for the petitioner in the interest of justice, re-notify petitioners. We say petitioners.
2711.
See you next time.
2711. Serial number 20. Government advocate.
Yes. What is this case of GC Raju?
Yes, your lordship, it is, they have filed, a government have filed an affidavit on 15/6/2021 to withdraw the similar circumstances petitioners who are identical. And that is the reason the division bench of this court, they have to overcome this affidavit because they have given benefits to some. They cannot deprive.
There also the issue is 7 years with.
Yes,
PhD.
yes, they have completed.
Where is the judgment in GC Raju? And take that judgment, ma'am.
There are two judgments, your lordship, of two.
The same identical point?
No, the identical point that your lordship had expressed on the last occasion also, two judgment that government has to overcome the two judgment of this court, which had held the same issue.
So how much study leave you were given?
Here in this case, these petitioners never took any study leave. They worked in the evening college. That is what the learned single judge has also taken.
No, study leave for 3 years.
Not
3
3
years. No, for these petitioners, they have not taken any study leave. They studied in the evening college and they worked in the day college.
They pursued their PhD also.
And they completed their PhD also. That's what.
After how many years they completed?
They took 6 years.
But you were not, you were working and you were getting pay also.
No, that is the condition when they pursue their PhD, they get the remuneration. So they worked. The similar circumstance, your lordship, there are so many issues the government has concealed where they have taken benefits and subsequently they have not completed PhD and government have not recovered the same from them. Only this, after a long gap, they are trying to bring out this issue.
What are the benefits which are being taken away from them, by them, from you?
Same,
Pardon?
Increments.
no, they have given, after
Increments.
your lordship there, you,
Sure, okay, increments is subject to you having PhD.
yes,
Yeah.
yes, the increments will be given on completion of PhD. Your lordship, the increments will be only given after completion of PhD, and in 2016, they have done.
Now, tell us, 1 minute, 1 minute, that's a different.
You're not doing it to the part of the.
Just 1 minute. Now, when, just give us the dates. When did you started PhD program?
So far as.
In
Continue.
2003 onwards, it comes in my petition.
Did you complete?
Some completed in 13, some completed in 16.
When was the increment given?
Increment is given
After
all through.
completely after completing the PhD only. Your lordship may kindly turn to page 129 of the respondent appeal.
You have to only give us few dates, that's all.
But you can kindly say.
Here, but what is important is, when you have PhD, you will not get increments.
No, here
Yes,
increments were given.
Only after
But
completion of a PhD. All these petitioners got increments only after completion of PhD.
From
But
which year?
that is 2016 they completed, they are getting
When did they get increments?
only after completion of PhD. That is even the regulations.
So your lordship, as far as the petition, my client is concerned, we were getting their increments. The increments was sought to be stopped in 2019 because he had not yet got his.
When did they start giving you the?
I was getting my increments because I was working right through. Yes.
But
And your
subject
lordship
to you
kindly
doing PhD.
no, it was not subject. What they said was that in case he doesn't finish within 7 years, then the increments can stop. That is what the AICT regulation states.
The increment stop, but no recovery.
No recovery, and that recovery was stayed by the High Court, by the Honorable High Court.
So they intended to recover also.
They intended to recover for the past 2 years, then that was stopped, and thereafter pursuant.
Now, how is this GC Raju relevant?
In these judgments, your lordship, they have stated that since they've just exceeded it by a couple of years, it does not matter. In the meanwhile, the government has issued orders in all these cases saying, withdrawing their order of recovery. So when they've issued orders in respect of 3 to 5 of them, stating that, okay, these orders, since they just took a year or 2 or 3 excess to complete their PhD, the orders of recovery.
There are no 2, 3 years. We want to know how much was the difference? How much within 7 years you were to get the PhD?
I was supposed to get it within 7 years. I took 2 years extra. I enrolled in 2008. I completed in 2019. 18 or 19. When did I complete? 19.
So then tell us one thing, why not GC Raju will applicable?
Here we have given 7 years.
You have not given us.
They have not completed it that time. That time also they have not completed. They are not entitled for that.
Did you give benefit in GC Raju's case where people have gone beyond 7 years also?
Yes.
Where people have gone beyond 7 years?
They have, in the appointment order, there was a specific condition that they have to complete PhD within 7 years. That was accepted by them.
But then why did you give concession in GC Raju? Or I will give concession in one case, I will not give concession in another. This is wrong.
And now, your lordship, I have.
Is still this rule still in vogue?
Yes, it's still in vogue, and as recently as in 2024.
You know what we'll foresee now?
Yes, please, Your Lordship.
Those 7 years, I will do it in 15 years.
No,
That could be the tendency which will develop.
Your
The
lordship, for
point
that,
is-
this thing will not happen.
This will not happen.
Your lordship.
Why not happen? Tell us.
Because the ACT regulation 2003 and 2000 subsequent previous regulation, there was no stipulated time to complete PhD. Only in 2016, ACT notified that within 7 years they have to complete. Earlier to that, there were some problems also. The first problem was they can't pursue the PhD because they were appointed under state government, for which they have to complete 5 years to join the PhD course. So these people gave an application that they will work and do part-time studies. So they were permitted to do PhD. So the regulation 2016 came only in the force 2019. These people joined PhD in 2003 and completed in.
We want to know how many petitioners, when did they complete?
Yes, Your Lordship.
Let's see.
And there's just one more. Madam, can I request you kindly? You're ready, right?
Your Lordship.
He's getting salary. But here they are working and getting salary without any.
Only prospectively it will, if even the regulation is applied, it will apply only from 2019 onwards. Those who are doing, not the people, the professors who joined much earlier. These conditions were not there in the earlier regulations. Only in the 2019 regulations, this were included. And they were only they say that till they complete the PhD, the increment should be stopped. So these regulations will be applicable only for the present employment.
We want to know how many years you have taken to.
Yeah,
complete
Your
PhD.
Lordship, first petitioner joined
Petition. What is this written number? So far as repetition 31613, please, Your Lordship. The petitioner joined, Your Lordship, the PhD in 2008, enrolled, completed in 2019.
90?
Please, Your Lordship,
Just imagine.
because he worked right through. He worked right through, and he has since retired, and they withheld his retirement benefit on this ground,
Oh,
in spite of the,
but why have we withheld?
they withheld, and that petition is pending.
You will only say that adjust this amount, release the rest.
No, but how can they do that in that case? In July 2024, Your Lordship, they've released the amount in respect of one in the same institution.
Okay, let's see this. How many petitioners are there? You do one thing, just prepare a chart, we'll just pass over. We'll take it up after lunch. Just prepare what are the areas.
no, subsequently, Your Lordship.
What this
We also
court
have
has said,
please.
oh, this is our order.
Huh?
I don't know where did I read it.
Single digit. Very good.
You must see, this is something,
Ask them for a copy, no, what is the point of sending it to them? They give one copy.
This will come against you, ma'am.
Unfortunately, the other judgments of the other division bench was not brought to your lordship's notice.
Your
The
lord-
other two benches, the two orders have not brought to the notice of this
We will
honorable
look
court.
into those also. We will look into those also. We will hear you after the Passover.
Your lordship may kindly your lordship has to look out the regulations when they joined the PhD. At that time, regulations, I have filed in my statement of.
We will see it. File your submissions. I think that would be better. Counsel for the parties to file their written submissions. Along with the judgment they want to rely.
Please.
And you have got this copy?
Yes, I've got this one.
Just meet that also in your submission.
Will do.
We recollect. Next we notify.
510.
Next.
21 Arjun, 22, Shri Vishwajit Rai. 22,
This is just list on 21. 10.
serial number
Belong
23.
21, 10.
23, Shri Vivek Hulla.
Submissions we file. You will file, Mr. Vivekanand.
Please, may make one more submission, minutes.
Yes.
Challenging the very same impugned order, the state has also filed writ appeal, minutes. WA number 1559 of 2023. Your lordships have issued notice on 10/9/2024.
Which is the date there?
Date is given, minutes, on 4th of November, minutes.
We'll have it on the same day.
Same day, minutes.
Re-notify counsel for the parties to file their written submissions. Along with the judgment they want to rely on.
Please,
This arises from the same impugned order.
same impugned order.
You just inform the court on that day.
Please,
So that both can be clubbed.
please.
411.
Interim order, if any, to continue till the next date of hearing.
24 Arjun. 25. Srinivas K N Srinivas. 25.
None for the petitioner re-notify on.
2811. Serial number 26, Government Advocate.
This I have to file written submissions, madam.
You have filed.
No, madam, I have to file.
Submissions be filed by the counsel for the parties. Along with the judgment, they intend to rely upon, re-notify on.
2711. Serial number 27, Shri Jeevan K. 27.
I'm the respondent here.
Very interesting. This is what, this is also come from that, Yes. Then you have the file. Yes, show us the file. You appear for whom? Who appears for the petitioner? You appear for petitioner, Mr. H. Vishwanath. you.
I am the complainant in the lower
For the
court and the
complainant.
respondent herein.
Oh. Where is the last order? When was the last order? When was it listed? Was there any stay?
Until the next date, Your Honor, that was the stay. And after the,
But what do you say?
no, it was the stay only for, it's a time bound stay, Your Honor.
Yes, you're right.
And when it is this time bound stay, I appeared before the lower court and said that this is the stay that which is already been, no, it has done its thing. And there was no extension of the, stay. On that regard, I submitted to the court and they,
But was there any express or was there any order? Express order, there is no express order, surely not
no,
extending
there was
the
no,
stay.
there was no express.
But was it, but what do you say? Where is your application? Let's see your contents of your application. Have you filed any application? What, this is, you have just moved the court. So, see, it may be a mistake at the court.
And my submission is another one submission now. There is at least 4 or 5 related matters that we have submitted before this court in various writ petitions. And the commonality of the fact is the LGC 42, that which is the subject matter of this case.
Pardon, come.
Commonality of the fact is the subject matter of this court also, is the fact that which is narrated here. When it is narrated, when it was already narrated in 5 writ petitions, again the same thing comes over here, only the prayer is different, that is for the discharge. Discharge application is rejected, that's they have challenged that. That I have no problem. The problem is, they have narrated the facts in so many issues, and they have hidden and suppressed all those writ petitions here.
We will look into that.
So that I have already filed the memo.
Yeah.
So I have already filed the memo.
Only limited, he is saying that interim order be continued.
No, but unfortunately it is, it's the pending matter before the lower court is of 2016. And they wanted to elongate and they, they misuse the proceedings of the court. And when they misuse the proceedings of the court, I am stuck there in the court as the victim.
But what we see is on 18/1/2024, when the matter was listed was adjourned to 1/2/2024, the interim order was continued.
Interim orders continue. After 1/2/24, there is no extension of the order that which, that they say there is a stay order there.
No, he can't say so. That's the reason he has moved.
That's
He says that may be extended now.
But unfortunately, the counsels of the, the petty and the accused there in the lower court, they argue saying that there is a, stay, interim stay.
No, but that's possibly they were under the impression there is a stay which has been extended. But actually, maybe he has seen this order or he has seen the order on the net.
Imagination is
stating that
totally.
There is no interim order extended.
My
So that's
humble
the reason-
submission is imagination is totally different and the fact is totally different.
Yeah.
And the unfortunate it is the fact that they are trying to create in the lower court as it's,
We will
and my humble request is to not to, we can issue the stay saying that, which is a subject matter until the final, subject to the matter of the final disposal of this court.
No,
That's
what
fine.
what we will only say this is the interim order which was passed on 1/2. 1/2.
Yes.
No, sorry, that is Mr. Dinesh Kumar. 18/1 shall continue till the next date of hearing.
That is 11. Today there was, the proceedings in
What
the
is the
lower
date
court.
of hearing now? What is the date of hearing? 6/11. It will continue till 6/11, that's all. We will see it on that day.
But, after that, let them not, let this court be very specific, saying that is only up to 6/11. After that, it expires.
We will say so.
And also, I would like to draw the attention of this court is, in the second matter, the position that which is taken by the petitioner is that, he is not a part of the issuance of the,
This is 22328 and 8192 also arises from the same proceeding.
same proceedings, Your Honor. And also, I would like to submit an affidavit that which is filed in 1998 by the petitioner to the CMC saying that, they are submitting, they are handovering the land to the CMC for the, thing. But they were aware of the land that which is available for them to construct, that is including the builder knew it. Because builder have signed the affidavit before the CMC, and the copy of the CMC said that is the part of the evidence in the lower court also. So they are trying to suppress so many facts. Not only that.
You have highlighted the facts
Where?
in your submissions or in your response.
No.
File your submissions. You put everything on record.
I'll put everything on record. And also there is a criminal petition that which is filed,
Whatever you want to say, we will give you opportunity to file submissions.
Yes, Your Honor. By next date, I will submit. Before next date, I will submit.
Just say this, where is the 6/11 date? Which order says 6/11?
In the lower court.
No, we want to know what is the date here before us.
No date. A short date may be accommodated.
We will give a date here.
Yes, Your Honor.
Just say that this petitions have been listed in view of the mentioning, ma'am. In view of the memo moved by the counsel for the petitioner. Where is the memo, ma'am? Memo moved by the counsel for the petitioner on 23/9. No, he says here. On 21/9. Memo moved by the counsel for the petitioner. We will only say this. In writ petition number 22328/2023. The memo reads as under. Read ad under. Mr. What is your good name?
I am Chandrasekhar V.
Chandrasekhar, the respondent number 1. The original complainant.
Yes, original complainant in lower.
He is present in the court. Full stop. He has been heard. The order dated 18/1/2024 passed in this petition is extended till the next date of hearing. That is, just give a date in November.
20th November.
Full stop. Now connected matter also list on the same day?
Yes, sir,
Same date. What is the date?
20th November, sir.
20th. Just note down 20th November, counsel for the parties shall file their written submissions along with the judgment they want to rely upon at least 1 week before the next date of hearing. Next.
Much obliged.
28, Shajesh Kumar.
Yes.
Petitioner is a landowner, who had entered into a joint development agreement with corporate debtor. And after that, the petitioner had terminated the agreement as of 2017. Thereafter, the petitioner had gone to the trial court.
Then file.
Yes, sir. And the petitioner had gone to the trial court for adjudication of the termination. And the trial court, my lord, as early as 13/12/2019, had granted an order of status quo. My lord, one of the vendors to the.
Just one. We'll see that. Ma'am. The connected matter, they will stay, that must also continue. Just check up.
There is order to include our absolute 3/3.
That's absolute stay.
This order is, what is it?
Further proceedings are.
What is the necessity of moving it back?
Where is it?
No need for us to say.
My lord.
Yes.
Yes, my lord. So therefore, my lord, my submission for my lords is, being the landowner, having terminated the agreement and chosen a remedy before the trial court where I was protected as early as 13/12/2019. My developer, my lord, the corporate debtor, had suffered a petition before the adjudicating authority NCLT under section 9. And on 9/6/22, my lord, at volume 2, page 403, an order was passed by the adjudicating authority admitting the
But
petition
what
as
are your
against.
prayers here?
My lord, what has happened, my lord, is, as my lord is aware, that the period for CIRP is 330 days. And one extension is permitted. The extension, my lord, was permitted on up to 3/3/23. Now, after 3/3/23, my lord, the company has to go for liquidation. There's no continuation, only as per section 12 of the IBC Act, my lord, only one extension. My lord, the adjudicating authority, my lord, even after 3/3/23, is continuing with the proceedings, even though it has no jurisdiction. And that is one aspect. Second aspect, my lord, is my property, which is the subject matter of the suit, where I have got a status quo order.
What is the present state of proceedings?
My lord, it is being adjourned from time to time
What is the date?
with no effective hearing, my lord. 4/10, my lord. 4/10. And my difficulty is, my lord,
No liquidator.
not yet. The RP will eventually become. In fact, the committee of creditors say, we don't want to go for liquidation, which can't be as against the statute. My difficulty, my lord, is as per the impugned order, my property, without me being heard, the Honorable Adjudicating Authority says that there are a bunch of creditors, my lord. They say that my land, even though it is not subject to development, should be the only source to recover the money, even though I'm not even heard on the matter. I filed an application for intervention, notice is ordered. I even filed an application for.
How come you have involved, how you have come in the litigation?
I have filed an application for intervention because the corporate debtor had signed a joint development of my land. My land was given to him under a joint development agreement, my lord, and I had terminated it at Ink page 278 on 14/12/2017. So I had sought for termination of the joint development agreement, which contemplated that I have step-in rights. Therefore, if the developer does not commence the building, I have the right to step in to complete.
So now it's 4/10.
Yes, my lord. 3/3/23.
We may have to hear you on.
Yes, yes. Yes, my lord.
This requires need to look into.
Yes. If the IRP is issued notice, my lord.
No, well, we want to hear you from before we issue notice also.
My lord, the reason is, my lord, two aspects, my lord. When section 12 says that only one extension is permitted, I request my lord to kindly see page 455 for a moment.
But tell us one thing.
Yes, my lord.
Let's assume for a moment, you are still there before the NCLT?
My application is undecided.
That you will press for your
My
application.
lord, the difficulty is there are 30, 40, because as home buyers, once they come in, we become the last persons to be heard.
There are multiple projects. Our application filed as early as 28/11/22 at ink page 403 is lying in abeyance, my lord. 28/11/22. Which is that project? My lord, mine is signature, my lord. As per the impugned order, it's at ink page 34, para 10. Para 10, ink page 34. Mine is project canopy signature, and I filed an application for recall of this order because I needed to be heard.
So what is happening? Others' applications are also not being heard. It's just
Being
simply
adjourned, my
re-notifying.
lord, from point. That's the difficulty. If my lord is pleased to see the extension,
How parallel proceeding, there one, here one.
my lord, my submission as per no Mohammed, my lord, a court without jurisdiction cannot hear. When there's only one extension.
How can you argue that you file your application?
No, I'm saying for my lord's kind consideration, after the second extension, after 3-3.
That's right.
Yes.
You can argue that.
That.
You can argue that. But will that be considered by the NCLT or by us?
My lord, my difficulty is NCLT is not hearing me. Even if my lord is pleased to direct NCLT to pass an order on my application, because I filed an application as of 28/11/22. I filed a recall as on.
Just a simpliciter adjournment.
Yeah.
All.
Yes, my lord. My lord, I'll just pass on the order sheet. So we have got it up to 29/4/24. Give me another copy. We have printed out the please see from page 13, my lord.
Which is your IA?
My lord, my IA is 203 of 2023. 22. Volume 2, page 403, my lord.
No, part of this orders.
No, it's not.
203 is there.
203, my lord.
Page 7, issue notice.
Yes, my lord. That was issued, my lord, on 31/5/23. It's written as 25/5.
Which is the last order you have annexed?
Yes, ma'am. That's at ink page 17. Even my lord is pleased to see ink page 16.
What happened after 24/4? What happened after 24/4?
Lord, my learned friend says it's just been adjourned, my lord, because we appear online.
See, they need to look into it, not we.
My lord, the aspect is, my lord, that when the time is over.
Right.
Yes.
And you must have said so also before the
Yes,
NCLT.
my lord. In fact, my lord is pleased to see that the extension order is ink page 455 in volume 2. Ink page 455.
Do one thing, you file those orders also, the latest orders.
Yes, my lord. The only two, my lord, the only two orders. 24/4 and it is supposed to be listed on 3/7/24. And after
And
that.
what are the other applications? Are the applications, other applications, similar applications?
No, my lord, there are home buyers. What's happened, my lord, this developer was quite popular. He had around 5 or 10 projects. So home buyers would file different applications for various relief for their project. In my case, my lord, I had two parts, phase 1, phase 2. Phase 1, he completed, which is a subject of litigation. Phase 2 is a separate plot of land, which is called canopy signature, which he has not done anything, and therefore I had terminated in 2017. But by this order, I think page 34, my land is now being said that whatever the issues are, it will come there. I should have been heard. Therefore, I filed an application. Even for recall, I filed it as early as, my lord, 23/6/23. 23/6/23. An extension was given only at.
Let's see what transpires on October 4th.
Please.
Coming, na? Just say that re-notify on Give it in second or third week of November.
My lord, what my learned friend is rightly saying, my lord, in page 34, this order, I think page 34, para 10, would go against my,
We are with you on that.
Yes.
We have expressed ourselves.
Yes.
Surely, yes. This must be appreciated by the NCLT.
yes, my lord,
Next.
1911,
grateful.
serial number 29, Shri Madhusudan. 29.
I appear for respondent number 1 in this matter.
Yes, ma'am. Then which is the number? ma'am? Yes,
My lord, I am the petitioner V. Krishnamurthy.
yes.
I'm 87 years old. I'm a heart patient. I've been trying to settle this pension case for the last 15
Sit
years.
down. Sit down.
There's a Supreme Court order. There's a Supreme Court order also. The order given by the lower court is against the Supreme Court judgment, is famously known as G.S. Nakara case. It's a constitutional bench judgment stating that there should not be any discrimination between the pre-cutoff date pensioners and the post-cutoff date pensioners. My sixth pay commission report was given in 2006. I belong to the pre-2006 pensioner now. 2006, I was not given the benefit of that, despite there is a Supreme Court order in DS Nakara case, ignoring that order. The respondent number 4, I have the problem with the respondent number 4. We have relied upon a government order which has been quashed by the CAT principal bench and later on upheld by the Supreme Court of India in Manipur, in the SLP also. Ignoring all those orders, the respondent number 4 has not fixed my pension properly. Respondent number 2 and 3 have agreed to fix the pension as per the Supreme Court order, whereas respondent number 4 has relied upon a quashed Government of India order dated 30th of July 2015. Specifically says the principal bench of the CAT three-judge bench quashed that order in OS 655 of 2010. Despite that, the Bangalore bench, before which my petition came, they ignored that order and said that the pension already fixed is correct, which is wrong according to Supreme Court order. And according to my employer, who is respondent number 2 and 3, they have agreed. But respondent number 4 has not agreed, relying upon a quashed Government of India order dated 30th of July 2015. So my prayer is that I'm a super senior citizen, here is 87 years, having heart problem. I request my case to be disposed of as expeditiously as possible. This is not my short submission, my lord. This is not my short submission.
Please take your seat. Let us see what he'll say.
My lord, Mr. Madhusudan today, my lord, is unwell. A short date and immediately of opening. For final disposal, it may take enough.
See, you have seen the judgment.
Yeah, yes, my lord, yes.
See, that's the point.
Yes,
Only with now he will come, he will again, with the age against him.
No, finally, my lord, immediately after reopening day, my lord, I will, for final disposal.
We can do one thing.
Please, my lord.
We will reserve it. Let him not come again.
Yes, my lord.
We'll just give you submissions. We'll
Yes,
look
my
into
lord.
it. Mr. Krishnamurthy,
Yes, my lord. Yes, my lord.
the counsel is unwell. The counsel from the other side is unwell.
Okay, doctor.
So
My
they are
lords, I
taking it-
appear for respondents, my lords. I think he's referring to his own counsel.
No. Yes, my lord. Mr.
Ma'am, you
Madhusudan,
appear for whom?
I
respond.
appear for respondents, my lords, Union of India.
I appear on
You
behalf,
represent him?
I represent on behalf of Madhusudan, my lord, appellants.
No, for Mr. Krishnamurthy?
Yes, my
I'm
lord.
the
Yes.
petitioner, my lord. I'm the petitioner, my lord.
Oh, yeah. So he is representing you.
Madhusudan is responding.
Yes.
Yeah, Mr.
Madhusudan is my
Madhusudan is
counsel, my
representing you.
Yes.
He is stated to be unwell. You should have informed him.
My lord, I am seeing here.
Yes,
here. I have seen him now.
Yeah, right.
I have not.
I have not seen him earlier.
Do one thing, you don't take the trouble of coming to the court. Yeah, can you hear us?
Okay, wonderful.
Yeah, so you can appear virtually. You can appear virtually, don't come to the court. Mr. Madhusudan is unwell.
I don't have facilities for virtual hearing, my lord.
Okay,
I'm elected so far as digital transaction is concerned. Because I retired in 1994 when these things were not available to
So
my.
don't come, let Mr. Madhusudan come to the court and argue the matter. He is unwell, so we will adjourn it.
My earnest prayer is, let it be disposed, because I don't know how long I will live. I'm 87 years old, I'm a heart patient actually.
It's all right, we will, yes, we will give a short date. Adjourn.
As early as possible. I want to enjoy the benefit of my pension during my lifetime, my lord.
Surely, yes. The request is made on behalf of Mr. Madhusudan, advocate appearing for the petitioner on the ground that he is unwell. Just say re-notify on. Give it in October only, ma'am, after vacation, immediately.
Yes.
15:10.
Just inform the date to him.
My lord, may I request for it on 21/10, my lords?
21.
21:10.
Just inform the date to him.
I'm grateful, my lord.
My lord, we'll file a written submission. My lord.
Yes.
Otherwise, matter may be reserved, my lord. In the meantime, we'll file a written submissions.
No,
Pardon?
my lords, I have not been heard in the matter. Notice has not been ordered as yet.
We will hear it. You will hear
Very
it.
well.
Come,
Very
come.
I'm grateful, my lords.
Next.
30, adjourn. 31, Shri Satishke.
We'll have it after lunch.
Yes. Some difficulty today.
Why, what happened?
Post lunch, some difficulty. Forum did not.
Tomorrow is the last working day. I don't think my lord's board is overboarded.
And we'll have it after vacation.
After vacation, my lord, same combination, I don't know, my lord.
They
Same combination is there, I'm very happy.
see that. Just say that Mr. Arbati, who is appearing for respondent number
3, 2, 3, sir. 3. PL Sanjeev.
3.
say he is in personal difficulty. So at his request, re-notify after vacation. That would be fine. Re-notify just immediately after vacation. But with an understanding, whatever transpired. Yes,
My lord may say status quo because if combination changes, my lord, it's difficult for me to. If same bench is there, no problem at all.
so we will make it part of, suppose for a moment there is change. He may be right, Mr. Bhagwat may be right.
It will come up.
It will come up before us.
Yeah.
Let's see that.
That will come only on Friday, my lord. Every Friday bench.
What is the difficulty for you, Mr. Bhagwat?
I don't know
That
difficulty.
assurance is there.
I know difficulty. I know it.
It's all right. We will give a date. Just give a date. That assurance is there. Just show the last orders. We say, we have heard Mr. Bhagwat to come up for the arguments of the respondents.
I know the order sheet, my lord has done it, my lord.
Yeah. Thank you. We'll just give a date.
Yes.
Lordship, serial number 34.
Which date?
You've given the date, ma'am.
16:10, sir.
1610. Yes.
Serial number 34, my lord. Some difficult.
1610, nah?
21:10. Yes, sir.
17th is a holiday, Mr. Bhagwat. Next.
Serial number 34.
What is the difficulty? Mr. Bhagwat is going if you want a change of date.
21, let it be.
He says 21,
Some difficulty for my friend.
21:10,
I'm at your disposal, my lord. I can't say. My argument is
21:10,
that
34, yes.
Please, my lord, this, some difficulty, it may be kindly be taken up after. Because
man who has
the,
not been regularized more than 30 years.
the
but he
issue
was
is,
being sponsored by the employment exchange. Even after 30 years, they have not regularized.
it may be taken up tomorrow, my lord, because
You appear for whom?
I appear for the petitioner.
petition. I am for the respondent, my lord.
You are for the respondent. At the request of counsel for the respondent, renote. We will give a convenient date, Mr. Shetty.
Please, sir.
We can't have it tomorrow.
411.
Next.
Serial number 36, my lord.
Yes.
My lord, I pray for a
And
short
like
accommodation, my lord.
411 short day. Next month, may not any date, next month, any date, may not subject to.
It's, we are giving effectively next month. We are on 30th September. So almost in October. So next month is November. We'll have it, Mr. Shetty. It's not possible to accommodate everyone. Board is heavy. That's the reason.
Serial number 30.
Last week of October, may not subject.
What is the date given, ma'am?
411, sir.
11th October. Let it be so, Mr. Shetty. Don't.
Serial number 36, my lord.
36,
Yes,
yes.
my lord. Your lordship may kindly have it after vacation, my
Who
lord.
is the other side?
My lord, friend is here.
At the request of counsel for the petitioner, re-notify on. Just give a convenient date.
1411.
Much of.
Yes, ma'am. Tell us.
Serial number 35.
Which number?
Wait.
32, yes.
35.
At the request of counsel for the petitioner, re-notify. Pardon? What is the interim order?
Arrest warrant issued for the last 2 days. The matter is coming up on 5th, that is Saturday, in the state commission.
Has been issued. What is the order passed?
Regarding the stay order of the arrest warrants issued on
Ma'am,
2
it
days.
shows that. Who appears? Is anyone appearing for the respondent?
The notice has been served, my lord.
We don't, just do one thing, come after lunch. Let us see if someone comes.
Lord, one submission.
Yes.
Still number 35, my lord. I appear for the respondent number 2 and 3. Ms. Narayan Bhatt appears 4 and 5, my lord. May I request your lordship to have it after vacation.
Okay.
I appear on behalf of the petitioner, my lord. If it could be had after.
You appear for whom?
I appear for the respondent number 2 and 3.
At the request of counsel for the respondent number 2 and 3, re-notify.
And 4 and 5 is also present.
4, 5. 2, 3, 4, 5.
I'm not requesting for adjournment, but I can't.
At joint request, re-notify.
1511.
Let's a shorter date, my lord. Selection matter, any date in the beginning of
I know
November.
we are ready to hear us. If you are there after lunch, come after lunch, we'll hear you.
Just think for me.
Small matter, no adjournment, we'll come. Let us do some, okay? You come after
Achha.
lunch.
304 to disposal. ಸೊ ಅಂದ್ರೆ ಇದ್ರಲ್ಲಿ ತೋರಿಸ್ತಾ ಇಲ್ಲ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಸರಿ. ಇಲ್ಲ. ಓಕೆ ಸರಿ ಹೇಳಿ ಅವ್ರಿಗೆ ಅದು ಪುಟಪ್ ಆಗ್ಬೇಕಂತ. ಇನ್ನು 80.8 ಇನ್ನು ಸೀರಿಯಲ್ ನಂಬರ್ 48 ಇದೆ.
Yeah, doubt it's gonna reach Naveen.
80.8. Okay. Sir. Okay. Okay.
Morning nicely and casually walking into
Won't reach now.
Huh?
I'm just asking, it won't reach.
We have for
Petitioner.
1, 2, 3, 4,
80.8.
5. Yeah, 1, 2, 3, 4, 5. Oh.
All.
On Wednesday, walking in Narcos. On 12/9, there was some wakalat. On 12/9, there is a wakalat.
Yeah, we only
Right,
fight.
on file of P 1, 2, 3, 4, 5.
There's no IAS details, so.
IA details are there. He filed LRs on record and put all
Yeah.
18/9.
Correct. CD also.
C
32, serial number 32, Shri Ashok GV. 32.
Appearing for the petitioner in this matter, my lord. This is the case in which there were contrary orders passed by the State Commission as against the orders passed by the RERA Court. The State Commission order said execute sale deed. RERA order said do not execute sale deed.
So, 3, sound, sir. 3, 3. Yes, sir. Twenty-eight 11. Serial number 33. 33.
Challenging an order passed by the special court constituted under the Karnataka Land Grabbing Act, my lord. I had instituted a suit, my lord, seeking for a declaration with respect of a particular land, my lord, which was granted to me by the state of Karnataka. I was in possession of that particular land from the year 1950. The grant was made in the year 1964. The grant was for a limited period. After that particular grant, my lord, I continued in the possession of the property. Then, my lord, I apprehended certain action at the hands of the Tahsildar. I filed a suit for a declaration that I am the owner of the property. And also I sought for a injunction order, my lord. Then, my lord, status quo order was passed in my favor, my lord. And there was that particular order was in vogue. When that particular order was in vogue, my lord, written statement was filed by the government of Karnataka. They did not take up any contention that I am a land grabber. The contention is that my possession is unlawful. Then, my lord, issue was also framed. After establishment of special court under the Land Grabbing Act, my lord, then, my lord, this particular suit was what was instituted before the court below was transferred to the special court constituted under the Act, my lord. Then, my lord, the suit came to be dismissed on the ground that I cannot put forth the claim of possession, that is the adverse possession, on the basis of a judgment of Dharmapal. Then, my lord, agreed by that order, my lord, I filed a writ petition before this honorable court. That particular order was passed by the special court of the, sorry, my lord. My lord, the date of hearing is, 310, my lord. This order was passed, my lord. Sorry, my lord. 1611, my lord. 1611 of 2023, my lord. Sorry, my lord. Sorry, I understand.
What transpired from that day and this day?
My lord, there is no further progress in that particular matter. The order sheet I have produced, my lord. The order sheet, my lords would find at Annexure A, page number 31.
I appeal for the state, enter all respondents.
Okay.
Lord, the impugned order is Annexure B, page number 57.
My lord, the order of the civil court is at annexure N, my lord, page number 117, my lord. Annexure N starts at page number 114, my lord. This order, by virtue of this order, my lord, the matter was transferred to the special court, my lord. Then I appeared before the special court, my lord. The special court on maintainability dismissed the suit, my lord. Then I filed a writ petition before this honorable court on the ground that in view of the judgment of the Supreme Court, that is adverse possession, not only a shield, it is also a sword. This honorable court. Yes, my lord. Yes, ma'am. Yes, ma'am.
The interpretation of section 20 was involved.
Yes, ma'am.
While before the repetition. That the trial court has to record a finding based on the Lordship, kindly see page number 118, para number 5.
Yes.
In the present case in the hand, the plaintiff has filed the suit for declaration and concept relief of perpetual injunction against the defendants. The defendants who are the officials of government are denied that the plaintiff is owner and possession of the property. The possession of the plaintiffs and their predecessors is illegal and they have illegally possession of the government property. The suit belongs to the government and the plaintiffs are unauthorized occupants in the suit land and therefore the plaintiffs are liable to be evicted from the suit land. The suit land stands in the name of the government. It is alleged by the defendant that the plaintiff are grabbing the court property. On this pretext, the suit was transferred from the original civil court to the special court.
Yes, ma'am. My lord, my submission is that, my lord, there is one particular judgment of this honorable court. There must be a foundational facts to confer the jurisdiction on the special court.
Let's be very clear.
Yes, ma'am.
Then if you are arguing an adverse possession, then the land belongs to the government. And to say that it will be an adverse possession against the government land, you are not ready to accept it.
It was a permissive property.
Half of everything would be now enforced there. It can't be any adverse possession against government land. Private land, yes, the concept of adverse possession would come in. 12 years without any demand, without any protest, enjoying purely. Not against government land. If we then everyone start claiming the government land and mine land on the basis of adverse possession. It is not acceptable.
Lord, my only submission is that, my lord, there must be a positive finding by the transferring court that I am a land grabber.
And belongs to the government. That's the judgment of this court.
This, yes, ma'am. Yes, ma'am.
Let's see the page 57.
Yes, my lord. I hope my lords are referring to Sunita versus State of Karnataka. Yes, my lord. The same, I am referring to the same, my lord. Yes, my lord. No, my lord. Earlier to that itself, I had come, my lord. The suit was dismissed without any trial, my lord. Dismissed at the threshold. On the ground that suit itself is not maintainable. By the special court passed an order saying that I cannot maintain the suit against a government land. And for that reason, I preferred an appeal. Sorry. Yes, my lord. That was dismissed by this court, by the special court, my lord. Yes, my lord. Yes, ma'am. Yes, ma'am. Any court or authority intending to transfer any proceedings to special court has to satisfy itself and pass an order in terms of what is stated herein above. In the absence thereof, there cannot be any administrative order of transfer of a case. In other words, it has to be a judicial order passed after necessary application of mind and law for transferring the matter. In view of the fact that there is no judicial order passed and there is no judicial application of mind to the factual aspects on the part of the principal civil judge and AMFC Mandya in the manner observed by us herein above. For transferring the suit, the order of transfer made to the special court is not sustainable. Hence, we are of the considered view that judgment passed by the special court in so and so is erroneous and same is to be set aside. I request my lords to kindly consider para number, my lord, 24, my lord. I may be permitted to read para 25, my lord. To para 24, there is a reference to section 2F, 2E, and 2D, my lord. Para 25, I may be permitted to read. An action, suit, proceedings brought about by any person seeking to protect his or her interest would establish that she does not come within the four corners of the act. At the most, the defense that can be taken by the authorities, if they have been arrayed as defendant in that proceeding, is to contend that the land belongs to them and that the plaintiff has committed an act of land grabbing, and therefore the plaintiff is not entitled for any protection or relief in the said proceedings. For an action to be initiated under the act, there has to be a positive action by the authorities concerned. In that, there has to be positive proceedings which are initiated against a land grabber. My lord, the basis for my title is the grant order, my lord, and continuous possession over the property. The grant order is referred to, my lord, in the proceedings. I don't have the copy, but that is an admitted fact. My name is entered in the revenue records on the basis of that grant order, my lord. And they are not disputing that fact. What was in the year 1964, my lord. They admit that there is a grant, my lord. Yes, my lord. There is no such, there is nothing as such, my lord. There is no collusion or.
My lord, to that extent, though it is a grant was available, I have to verify those records, and it was only a permissive possession. It cannot be termed to be an adverse possession to that extent. The grant was for a limited purpose, not for the entire period. It was only for a limited. That I have to verify. As per the submission of the learned petitioner counsel, he said.
No.
Only on such opinion being formed, the civil court will cease to have jurisdiction. Only such matter requires to be transferred to the
There are matter of trial, also. There are matter of trial. Evidence needs to be conducted.
He's saying, I have filed a suit, my suit has been transferred to here.
Because the contention of the government was, it was a government land. He is an illegal occupier, encroacher. Based on that, the suit was transferred from the original civil court to the special court.
Transfer the case to the special court.
Lordship, kindly see section 20. Transfer of pending cases. Any case pending before any court or other authority immediately before the constitution of a special court, as would have been within the jurisdiction of the such special court, shall stand transferred to the special court as if the case, cause of action on which such suit or proceeding is based had arisen after the constitution of the special court. The provision does not specify whether it is to be a land. To that extent, there is a finding recorded in page number, para number 5 of the trial court order, that it says that it is a government land. He is an encroacher.
But you say grant also.
The grant, the point of grant is not raised here.
And whether the court considers the grant issue.
So that grant issue is not discussed.
Right.
No, the contention of the government in the trial court was that since it is a government land, since he is an encroacher.
You're not, it's a government land, but given in grant, he still would be an encroacher.
That we have never admitted in the written statement that it's a granted land.
You want to know that? Was it a grant land which has been granted?
We will verify.
Because nothing has come on this. Where do you plead?
Yes, my lord. My lord, I plead it, my lord. I have been cross-examined on that aspect. And there is when I was, my evidence was, I concluded my evidence, I was, yes, my lord. And it was set down for the, my lord. No. It was initially before the civil court, my lord, in the year 2. Yes. 2017, my lord. Yes, my lord. My lord, then suit came to be dismissed, my lord. Then I challenged before this honorable court. And this honorable court, sorry. 2017, my lord. Yes.
That's the call of action. That's the call of action. Now, effectively, you are challenging the order of the civil court.
Yes, my lord. Yes, my lord. Yeah, I understand. I understand.
And what transpired between 17 and today? In between, you came to this court?
Yes, my lord. Because at the threshold, my suit came to be dismissed by the special court, my lord. Dismissed by the special court, saying that I cannot maintain such type of a suit. Then I filed a writ petition before this honorable court. Yes, my lord, that was restored. Then I filed an application to relegate the matter to the trial court, my lord. At that point of time, this order came to be passed, my lord. Because, my lord, there is no foundational facts to say that I am a land grabber. Yes, my lord. The court has come to a conclusion that without going into the merits of the case, at the threshold, suit cannot be dismissed. That is what has been ordered by this court, my lord. Page number 7, my lord, para number 7, my lord. Yes, my lord. Yes. I did not challenge it.
Today, what has to be considered is whether this adverse position can be ground.
My lord, my submission is that, my lord, to decide that particular aspect also, there must be a foundational fact. Lord, my submission is that unless I am a land grabber, they cannot proceed with the matter at all. Yes, my lord. Yes, my lord. That is at page number 57, my lord. Annexure B, page number 57, my lord. I filed application immediately, my lord, after passing of this order.
My submission before the special court was that, my lord, if my entry into the property is lawful and my continuation in the property. Yes, my lord. Yes, my lord. My lord. 2D and 2F. Yes, my lord. Of course, my lord. I need to place Ravindra Kaur Grewala also. I don't have the copy. That judgment, I will place it on record, my lord. There are two ways. The Ravindra Kaur Grewala, my lord, the Supreme Court says that if the government land, if it is utilized for the public purpose, a government land, for example, utilized for the public purpose, the principles of limitation or the concept of limitation has no application. Even after 100 years also, land can be recovered. If, yes, my lord, but there is a, yes, my lord, but there is a one fine demarcation has been made in Ravindra Kaur Grewala, my lord, in that particular judgment at last paragraph. If that particular land is not used as a public purpose, if that particular land for any public purpose, it is not being used. In such an event, my lord, for such type of property, the concept of adverse possession would be attracted, but the period is totally different. That is what has been explained in that Ravindra Kaur Grewala judgment, my lord. Yes, my lord. My application, my contention before the court below. Yes, my lord. Because unless there is a, because they admit that the land was granted to me, my lord. That particular cross-examination also has been conducted to that effect, saying that the grant was there for you for a particular period. After 1994 also, you continued in the possession. That is what they say, my lord, in the cross-examination. If my lords permit, I will draw my lord's attention to that particular portion of the cross-examination.
All the respondents. Take instructions, I'll take it.
No, I understand. My lord, that is the order passed by this court, my lord, on earlier occasion. That I will file it in the registry, my lord. I will file it in the registry.
I'll second.
7/11.
Any date, my lord, may be fixed, my lord. 7, yes.
Serial number 35.
Okay, good.
35.
This matter, as far as my understanding was concerned, your lordships have adjourned, my lord, but by mistake it has come. At 1:30, my lord, your lordships have observed that this matter will be taken. Renoted.
I'm only requesting for a shorter date in case. Yes. Yes.
14/11.
Achha.
36 adjourned. 37. Srinath Joyce.
Respondents, your lordship. We seek for adjournment, your lordship. Anytime after vacation, immediately after vacation, it may be taken. I'm appearing for respondent number 1, your lordship. Pray for time.
19/11. Serial number 38. Shri Basuraj.
Present, my lordship.
38.
Yes, my lordship. We challenged that order in the before this honorable High Court, my lordship. That is still pending. That CH order, that is the. It is still pending here.
It is pending. When is the date here?
My lordship.
What is the date?
I put up in the 2nd page, my lordship. Case status I have put up.
2nd page. When is the date? 2nd page. When is the date here? My lordship. What is the date?
Case status I have put up. 2nd page, my lordship. Case status I have put up. 2nd page, my lordship. Case status I have put up. 2nd page, my lordship. Case status I have put up. 2nd page, my lordship. Case status I have put up. 2nd page, my lordship. Case status I have put up. 2nd page, my lordship. Case status I have put up. 2nd page, my lordship. Case status I have put up. 2nd page, my lordship. Case status I have put up. 2nd page, my lordship. Case status I have put up. 2nd page, my lordship. Case status I have put up. 2nd page, my lordship. Case status I have put up. 2nd page, my lordship. Case status I have put up. 2nd page ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಯಾವ್ದಾದ್ರು ಕೊಡಿ 16ನೇ ಅದೇ 16 11 ಸರ್ 16 16 both the cases can be taken together, my lordship. Final. My lordship. Yes. 1610, my lordship. Yes, madam. Then we taken up together, my lordship. Similar and identical. These two cases are similar and identical. My lord, one small submission, my lordship. Actually, in the Madras High Court, as well as the Jodhpur High Court, these recruitment rules of the department have not been put off. That's why this has happened. After that,
1211, serial number 39, Shri Rajendra Kumar. 39. Twenty-eight 11. 40.
In this is a matter pertaining to regularization, lords. Regularization. Initially, lords, the authority appellant. Yes, it will take time.
Stay may be continued.
There is a
may be
stay,
continued.
lords, sir. There is a stay of.
20th November. Yes.
Yes.